With no objections, the motion is agreed to and the amendment shall become part of the bill. This concludes the fourth hearing on House Bill 5. Now I'd like to call up House Bill 160 for its third hearing. Here to provide sponsored testimony is Louis Tobin from the Ohio Prosecuting Attorneys Association.
Good morning, Mr. Chairman, members of the committee. Thank you for the opportunity to provide interested party testimony on House Bill 160 today. House Bill 160 largely addresses what our association believes to be some of the priority issues with adult use marijuana as it relates to public safety. These include: 1, protecting children from the harmful effects of marijuana by prohibiting the sale or advertisement of marijuana in any form that's attractive to children; 2, promoting roadway and highway safety by subjecting marijuana to open container-like laws similar to those that govern alcohol; and 3, stunting the growth of the black market by prohibiting the transfer of homegrown marijuana and also authorizing prosecutors to file any appropriate charge under Chapter 2925 for violations of home grow and for any other violations that fall outside of the scope of protections of our adult use marijuana law. We're also supportive of the provisions of the bill that seek to regulate intoxicating hemp products and require those products to be sold through dispensaries. That said, there are a few provisions of the bill that raise concerns for our members that we believe should be changed. Regarding home grow and double grow, it's the position of our association that the number of allowable home grow plants should be reduced from 12 to 6. A simple Google search on the yield of cannabis plants indicates that the average yield ranges from 1.3 ounces per plant for indoor cultivation to as much as 17.5 ounces per plant for outdoor cultivation under good conditions. Even at the lower end of this scale, a person with 2 or 3 mature plants is going to have an excess of the 2.5 ounces of plant material that's the allowable limit under current law and under the bill. At the upper end of the scale, a person can produce far more marijuana than they can personally consume. 1 ounce of marijuana can produce nearly 60 joints. One plant that produces 17.5 ounces of marijuana then can produce more than 1,000 joints. And the fear is that this creates the environment and the opportunity for the black market to grow in Ohio. Regarding the double grow provision, the bill provides in lines 1044 to 1050 that, quote, an adult use consumer shall not be subject to arrest or criminal prosecution for a violation of Division A1A or B of this section unless the number of homegrown marijuana plants the adult use consumer cultivates, grows, or possesses is more than double the number of homegrown plants allowed under those divisions. This is an attempt to align the bill with current 3780.29F and 3780.99F that provide that if an individual cultivates or grows double the maximum number of cannabis plants permitted, they're guilty of illegal trafficking in drugs. The meaning of the double grow language in current law, we think, is unclear. It has been our view that someone who exceeds the allowable 6 plant or 12 plant limits falls outside of the scope of protections for permissible activities and is subject to prosecution under whatever criminal statutes might apply. We think that the recognition in the bill that a double grow provision makes the person and 3780.29 that a double grow violation makes the person prosecutable is merely specific recognition of potential criminal liability for trafficking and the illegal manufacture of drugs. It does not exclude the possibility of criminal liability altogether for exceeding the 6 or 12 plant limits. The bill's prohibition on arrest or prosecution unless the number of plants is more than double, we think is much more lenient even than what's in current law in terms of allowing people to double grow. And we're very much opposed to this. Whatever limit the General Assembly decides to set for home grow, whether it's 6 plants or 12 plants or something in between, that should be the limit, and anything in excess of that should be prosecutable under Chapter 2925. Setting a statutory limit and then allowing people to double grow creates confusion, and I think creates an even greater opportunity for the black market than the current 12 plant limit. One more point that I want to make here related to our desire to be able to prosecute anything under Chapter 2925 for violations that fall outside of the scope or protections of this is that the penalty section of the bill says that for a violation of the home grow provisions, we're limited to prosecuting the person for drug possession. So if somebody growing a field of marijuana plants, we wouldn't be able to prosecute them. The fear is that we wouldn't be able to prosecute them for illegal cultivation or for potentially for drug trafficking. And I think we would just ask that that be clarified, that if somebody exceeds the home grow limit, prosecutors can charge whatever they feel is the appropriate charge under Chapter 2925. Secondly, the record expungement portion of the bill, it permits a person prior to the bill's effective date was convicted of or pled guilty to marijuana possession offense involving an amount of marijuana that is now legal to possess to apply to the sentencing court to have the record of their conviction or guilty plea expunged. This is redundant to what's in current law. Current law allows a person convicted of a minor misdemeanor offense to apply for record expungement 6 months after the offender's final discharge. It has been almost 18 months since issue 2 went into effect. Everyone who committed an offense that would be eligible for expungement under this provision of the bill should already be eligible for expungement under current law. There's simply no need for another statute to provide relief on this. And finally, on this point, the provision we think likely does not comply with a recent Supreme Court decision and state Cincinnati Enquirer versus Bloom that held that the mandatory juvenile record sealing provisions in 2151.356 are an unconstitutional violation of the open courts provision of the Ohio Constitution. The majority concluded that the open courts provision provides a presumption of public access to court proceedings, and that at a minimum, proceedings cannot be closed to the public without an individualized determination balancing the interests at stake. The bill, on the other hand, doesn't require any balancing of the interests. It merely requires the court to expunge the records or seal or expunge the records whenever a conviction meets the eligibility requirements. Finally, while we're supportive of the bill's prohibitions on public smoking and combustion and vaporization of marijuana, we strongly encourage the committee to consider also prohibit the public smoking, combustion, or vaporization of hemp. Otherwise, we're concerned that individuals will be able to avoid the prohibitions on the public smoking ban by claiming that they're only smoking hemp, and it's going to undermine the intent of the public smoking ban altogether. I want to thank the members of the committee and Representative Stewart and Senator Huffman in the Senate for their efforts to address many of these concerns. We're really appreciative of their advocacy on it, and I'm happy to take any questions the committee might have.
Great. Thank you for your testimony. Are there any questions for the witness? Ranking Member Isaacson.
Thank you for your testimony today. A lot of interesting and salient points. My question is around the Prosecutor Association's position, which I share, that we should have open container-like laws similar to those of corporate alcohol. But my question here is, what would that look like? Because the current bill actually doesn't have laws that are similar to alcohol. And so could you just explain what it would look like? What are the open container laws for alcohol that you're referencing? And what would that mean as applied to this bill?
Mr. Chairman, Representative Isaacson, I think the bill does have provisions that are similar to our open container laws that are similar to alcohol. I think it's kind of self-explanatory what those do. You can't have an open container of alcohol in a vehicle in Ohio. And I think the bill does really the best thing that you can possibly do by requiring marijuana to be stored in a manner that the driver or passengers can't easily access. So it has to be stored in the trunk or behind the last seat in the vehicle if you're in a truck or a van, for example. I really think that's the closest thing that we're going to get to our open container laws.
Follow up.
Can you just explain a little more? What are the punishments for open containers in vehicles for alcohol that you're referencing?
Mr. Chairman, Representative Isaacson, if a driver has an open container, I think they're going to be subject to a driving under the influence charge. If passengers have an open container, I think the punishment for open container is a minor misdemeanor.
Follow up.
So I think that's correct. So in this bill, would the punishment for the equivalent open container for a passenger be the same as it is for alcohol?
Mr. Chairman, Representative Isaacson, in the bill, the punishments for having an open container of marijuana, I think, are higher than what they are for alcohol.
Follow up.
Yes, please. Thank you. Thank you. So would the keeping with the principle that we should, as you stated, prosecute this and have in statute similar criminal penalties for alcohol as for marijuana, would the Prosecutors Association, do you have a position on having the penalties be equivalent for an open container of alcohol for a passenger versus for cannabis?
Mr. Chairman, Representative Isaacson, no, we don't have a position on that.
Good. Any other questions for the witness? Seeing none, thank you for your testimony.
Thank you.
Our next witness is Gary Daniels from the ACLU of Ohio. Mr. Daniels, welcome. And when you're ready, please proceed.
Thank you, Mr. Chairman. Mr. Chairman Thomas, Vice Chair Matthews, Ranking Member Isaacson, and members of the House Judiciary Committee, thank you for this opportunity to provide opponent testimony on House Bill 160. My name is Gary Daniels. I'm here representing the ACLU of Ohio. As this committee knows, Ohio voters across the state overwhelmingly passed Issue 2 in November 2023 by a 57 to 43% margin. On the evening Issue 2 passed, and continuing at least until today, opponents have theorized, speculated, and created out of thin air reasons why Ohioans so thoroughly approved of this change to Ohio law. Even though Issue 2 proceeded as an initiated statute, subject to changes by the General Assembly, and not a constitutional amendment, those same voters can be forgiven if they assumed any changes by the legislature would be minimal and complementary to the overall goals of Issue 2. After all, because the Issue 2 campaign opted for the initiated statute route and process, that means the General Assembly had 4 entire months to make changes, tweak language, and work with that campaign on these matters before Issue 2 reached the ballot. In fact, as part of that process, legislators in the Issue 2 campaign could have reached agreement on these issues and possibly kept Issue 2 from even reaching the statewide ballot. Obviously, none of that happened, but here we are today nonetheless. Now, 1.5 years after Issue 2's passage, HB 160 imposes a litany of negative changes on cannabis users, consumers, growers, and professionals to dismantle key parts of current Ohio law enacted by your constituents. For the sake of brevity, I will focus on 2 topics in my testimony: changes to criminal laws made by House Bill 160 and the cynical scrapping of the Social Equity and Jobs Program. With regard to the criminal laws, HB 160 changes and creates various criminal offenses. At worst, these changes can be interpreted as purposeful, designed to kneecap Issue 2. At the least, these changes fundamentally handicap the purchase, use, transportation, and sale of cannabis in the state. Consider the following, and this is not an exhaustive list of these changes and our concerns. For an exhaustive and comprehensive list, I'd refer the committee to Karen O'Keefe from the Marijuana Policy Project's testimony, which I think does a much better job of outlining the entire list of these issues. But for, again, the sake of brevity, I'll mention a few. House Bill 160 makes a criminal out of someone who shares a joint with another or gives a small amount of cannabis as a birthday or Christmas or other type of gift. Of course, no such restrictions exist for alcohol. HB 160 outlaws traveling to another state and returning with cannabis bought there. But Ohioans can still return home from their favorite out-of-state microbrewery with a can, 6-pack, or entire keg of beer. HB 160 inserts law enforcement into landlord-tenant relationships by criminalizing violations of a lease agreement that prohibit cannabis use in or on rental properties. Despite Ohio's bursting and expensive jails, HB 160 imposes a mandatory 3-day jail sentence and a total possible 6 months in jail, plus a mandatory fine of $375 to $1,075, plus a mandatory suspension of a driver's license for various first-time violations involving a motor vehicle. To be clear, this section is so radically broad, it applies even to a passenger in the back seat of a non-moving car on private property. Repeat offenses result in mandatory minimum jail time of anywhere from 10 days to 5 years. It is also worth mentioning here, HB 160, like current law, relies on an entirely inaccurate and outdated method for testing the impairment of suspected cannabis users. Current law also does not allow defendants to challenge in court their alleged impairment, but HB 160 doubles down on all this just the same. With regard to the Social Equity and Jobs Program, When they overwhelmingly passed issue 2, Ohioans approved a comprehensive social equity and jobs program modeled on those existing in other states. The general idea is twofold. First, to ensure some most affected by laws enforcing cannabis prohibition receive some preferences and incentives to now benefit from the new legal status for cannabis. Second, to provide an ongoing stream of funding for such things as criminal legal system reform and expanding addiction services. HB 160 tosses this all overboard in favor of a system quickly devolving to favor those with the most resources and influence. When issue 2 passed, there was hope among many employment and business opportunities for those who could benefit the most were not far behind. Instead, HB 160 appears designed to purposely shut them out. No one should be surprised if this trajectory accelerates in coming years. We ask that these concerns and the people they impact not be so callously tossed aside and to restore the social equity and jobs program as Ohio voters intended. Clearly, there are some positive parts of House Bill 160, but they do not outweigh mandatory jail sentences, criminalizing behavior to make things worse than before issue 2, gutting reform efforts and funding, and kicking to the curb those most impacted by Ohio's nonsensical, never-ending war on drugs. For these reasons and more, the ACLU of Ohio urges this committee's rejection of House Bill 160. Thank you, Mr. Chairman.
Sure. Thank you for your testimony. Are there any questions for the witness? Representative Callender with question.
Thank you. And just for the record, I'll probably have a question for everybody, so add me to the list. Thank you for coming and testifying. Thank you for some very valid and important points. Appreciate that. You did mention that there are some elements of 160 that are acceptable and some that might even be needed.
Mm-hmm.
And I guess I'm going to ask that you keep an open mind, and if you could make a list of amendments or things that would make the bill a good bill,
Mm-hmm.
an acceptable bill in your mind, and narrow it down to those things.
Mm-hmm.
Because I think, I guess that's my question. Would you be willing to do that quickly here?
Yeah, through the chair to Representative Callender, we can certainly do that. Again, our focus, just so the committee is clear, is not on sort of the industry concerns with issue 2. Our focus is much more narrower on the criminal law parts and, again, the social equity part. So we will be happy to get to, if the chairman is willing, we can submit this to the chair for the rest of the committee and, as well to your office directly. More thought and language with regard to those types of changes. And we've also been working with an awful lot of other advocates here in Ohio and across the country, I think, as you well know, on House Bill 160. So we will also put our heads together with them, and perhaps it becomes a joint submission, but no pun intended, but we will make sure to get you that information.
Great. Thank you.
Mr. Chair. Thank you. I think, as I've said before, I think this bill represents the most thoughtful of the approaches we've seen from legislators. I think there are some things that everybody in this room on all sides agree we need to deal with. I'll bring out my exhibit a little bit later. And if we could find some common ground, I think the sponsor has mentioned that he wants to have a fairly stripped down bill and some of the other things we can deal with later. I want to address all of the advocates in the room, the pro-cannabis advocates, to work diligently to come up with ideas and amendments that allow a bill to go forward to address those issues that we all agree need to be addressed, while leaving the other stuff to address one at a time in later legislation to deal with each of the sub-issues later. So I appreciate your you and your well-funded organization helping with that. Thank you.
Would you like to comment?
No response. Thank you. Through the chair to the representative. Thank you.
Okay. Representative Williams with the question.
Thank you, Chairman. So I've had my own concerns about portions of the bill, and I've drafted amendments, and I'm working with the sponsor. So I would love to see what proposed amendments you have. But part of your testimony concentrated on the social equity and jobs program. So I'm going to ask this blanketly without you giving a broad definition. When you say in your testimony that it's supposed to help some people, right? How are we defining that? Like, what do we mean? What's the intention of what you envision a program that has not spent $1 of the tax money generated because there's no clear guideline. It's a phantom program that doesn't have any direct outline of how we're supposed to respond to that as a state, how we're supposed to develop that program. So what do you see that program as, and what do you believe that some people in your testimony that you mentioned, what does that group look like?
Through the chair to Representative Williams, the reason, of course, for saying some is because, I didn't want to leave the impression that this would help all people, particularly those most impacted by cannabis prohibition. But, the idea, really was to say, we can help some people. We can create a framework. We can do it much in the way, even if it's not entirely perfect, of the issue of the language that was passed in issue 2. And I realize the ship has sailed, but again, I have to mention there were 4 months to do this before issue 2. There were no bills, no hearings, no nothing with regard to tackling issue 2 before it got on the ballot, or even saying, hey, legislators in that campaign, let's work together. So again, I realize that ship has sailed, but I think we can have a similar process where we assemble hopefully interested parties to talk about this a little bit more. If you have concerns, if other committee members or House members have concerns about the scope of that program and perhaps some of the language, but I think the overall intention of saying now that this is legal, there should be incentives, there should be outreach, there should be what have you for those people who have suffered the most under prohibition to now be able to take advantage of the legalization of cannabis.
Follow up?
Follow up, yes.
You shouldn't give me a definition of who those people were. Let's be clear what the social equity and jobs program was intended to do. The underlying thesis was that Black individuals were disproportionately affected by the criminalization of marijuana and cannabis in our state, and therefore they should have preferential treatment moving forward. You even used the word preference in your testimony. And we know from the Students for Fair Housing admissions case, the courts have clearly outlined that we're not going to be able to give race-based classifications, race-based preferences. We're not going to be able to use gender. We're not going to be able to use these classifications under the 14th Amendment. So I'm trying to understand how we're going to generate taxes and then give it out to groups by preferential treatment. I mean, that was the goal. Black representation in the cannabis industry was the open goal of issue 2. And that's unlawful. It's unconstitutional. So I'm trying to understand why we're trying to preserve a program that the state of Ohio cannot administer. We cannot use race.
Through the chair to Representative Williams, I see nothing in issue 2. I see nothing in the Ohio Revised Code that mentions race whatsoever. What it talks about and what we're talking about is people most directly impacted. Now, is there a disproportionate impact on Black Ohioans with regard to cannabis prohibition? Of course there is. We have the data for that. ACLU of Ohio itself has issued those types of reports. But there's nothing, like I said, in current law or issue 2 that mentions race whatsoever. The byproduct of the war on drugs is that some people, including via race, are most impacted. But we're not talking about just race with regard to that.
Follow up?
Yes.
See, that's the problem with the program. It wasn't specific enough, right? We know what the intentions were because we saw the marketing that was around it. Right? We saw the marketing that was saying that there was underrepresentation of Black individuals in the cannabis industry, and therefore we need this social equity and jobs program. We saw the marketing that happened under issue 2, but it's written so broadly that the state of Ohio can't administer it. So that tax money is just sitting there when it could be used for specific things like substance abuse treatment, reentry programs, things of that nature. That could be a positive benefit for the state of Ohio. So I'm trying to get an understanding of what the social equity and jobs program looks like. I asked for that specific definition from you, like what it looks like to the ACLU, and I don't get any specifics. I get a broad statement about policy that the state of Ohio can't implement.
Through the chair to Representative Williams, to be a little bit more specific, Ohio, of course, decriminalized cannabis to a large extent back in the 1970s, led by the Republicans. So what you don't have is the same horror stories that you hear in other states of prisons being packed with cannabis offenders. Nonetheless, you do have people who have lost jobs, who have spent some time in jail, because we did, at least at one point, we had cities that would have slightly, while it was a minor misdemeanor for possession up to 100 grams in Ohio, you did have some municipalities that said, well, we're going to elevate that under home rule at that point up to a full misdemeanor, not just a minor misdemeanor. So you did have people who were going to jail in certain municipalities around the state for that. People who have been denied professional licenses, people that haven't been able to enter various fields. But I doubt that this is something we're all going to hash out right here and now to everybody's satisfaction. And so if there's a larger conversation to come of this, certainly ACLU of Ohio, and I'm sure others welcome that. What we don't think is that we should say, well, let's just scrap all of it and not try to figure this out whatsoever. So if there's more conversations and discussion forthcoming with regard to this, certainly we hope we're invited to the table.
Representative Timms with the question.
Thank you so much for testifying today about the bill. I also have an issue with the bill, mainly because of the social equity and jobs program. I think the voters were clear in issue 2. And so I think I'm cautiously optimistic. I choose to see the glass half full. I think there is a way to define how we interact with people who have been harmed by prohibition in a way to allow them to enter into the industry so that it's not, only utilized by the wealthy and out-of-state companies who come in and take advantage of people who would like to enter into the industry. How do we make sure, based on the language in this bill or the amendment to this bill, how do we ensure that the little guy gets to participate in the program?
Yeah, through the chair to Representative Timms, I think that was certainly a concern of Ohioans well before issue 2. I can't remember off the top of my head when legal cannabis was last on the ballot, 2016, 2018, something like that, before issue 2. And that was roundly rejected. And what a lot of people, what a lot of voters in Ohio were saying is, what this appears to be is an effort so that only very few benefit from this, and not other people in ways that Ohio voters thought they should benefit. So they roundly rejected that effort most recent before issue 2, but then very overwhelmingly approved this particular effort. And I know from our own organization, we had our organizers going out, speaking to people around Ohio, speaking to them specifically about the social equity and jobs program. And I don't know how they would have voted otherwise. Perhaps they still would have voted for this, but there were a lot of people very much anticipating and excited about the social equity and jobs program in the hope that it would help maybe not even them, but some other people they thought were deserving of being able to benefit from the new status, legal status of cannabis.
Follow up.
Thank you, Chair. And so because of that, a lot of the work done on that campaign was juxtaposed against alcohol. And we've also heard, this committee have heard from small brewery owners, craft breweries. They're also fighting the big guy. And so do you think there are opportunities to align language so that the marijuana or the hemp growers can also benefit from programs that some of our craft breweries and small businesses across the state are able to take advantage of?
Through the chair to Representative Timms, indeed. And I think that's what was just sort of the most shocking part of this is that there appeared to be no effort to say, hey, even if we've got reservations about the social equity and jobs program, let's talk about this and see if we can find a way to do this, even if perhaps if it's a slightly different way or a different way to do this. But let's not just, exit right out, no discussion, no debate or anything. We think it's worth preserving. Maybe, of course, in the grand scheme of legislative compromise, it's not 100% the same way as Ohio voters passed it. But we think that any changes, as I mentioned earlier in my testimony, should be complementary to issue 2 and the goals of issue 2. But it takes people sitting down and talking this stuff out. In House Bill 160, at least as currently written, doesn't allow for that. It just says we're going to scrap this all together. And the problem remains outside of House Bill 160, too. This is in the current budget bill as well as scrapping the social equity and jobs program.
Follow up. Representative Mohammed with a question.
Thank you very much, Mr. Chairman. Thank you, Mr. Daniels, for your testimony. I could not agree more. I think a lot of the provisions that you covered are not complementary. These are substantial changes to what the voters wanted. I did want to ask you one specifically regarding the landlord-tenant relationship and the criminal charges that would arise from that. It's my understanding that typically under criminal law, these are generally civil charges, civil cases, correct? These are not criminal. So what sort of an impact would it have for it to be criminalized under this bill?
Through the chair to Representative Mohammed, true, almost all landlord-tenant relationships or disagreements are civil in nature, not all of them, but most of them. And right now, quite frankly, the penalty for violation is a minor misdemeanor. In the grand scheme of criminal penalties and criminal laws, that's of course much less serious, than a felony or even a misdemeanor. But the point remains, we are still, as a legislature, still criminalizing this, and it sets a bad precedent, not only with regard to cannabis, but other issues as well. And who's to say, should House Bill 160 or the Senate version or something else pass with regard to this, that's not elevated up beyond a minor misdemeanor or changed in the future with regard to this. And just in sort of a global sense, I didn't mention this before, but I have to wonder if this has changed so significantly from issue 2 in the initiated statute process. I think it begs the question whether supporters will be back someday with a ballot initiative to do this, shut the legislature out entirely. And just say, look, we're putting this on the ballot as an initiative, and this is what how Ohio voters will vote. And then there won't be these conversations.
Thank you, Chair. Just another follow-up as well, Mr. Daniels. You covered in your testimony some of the sort of discrepancies in treatment versus alcohol versus marijuana. Can you elaborate why that is? Why is there such a difference in terms of treatment, in terms of someone sharing a piece of marijuana with another person? Why is there additional charges? How does that compare to what other states are doing as well?
Through the chair to Representative Mohammed, there are perhaps other people here that can talk about how it's analogous or not to other states. As I often say, it's not a satisfactory answer, but I've got my hands full with Ohio, let alone what happens in other states. But what it's clear is this is treating things dramatically different than we do with regard to alcohol. The way it's written, the way it's framed, it seems like, okay, issue 2 passed, we're not happy about this. We're going to find ways around this by changing current law, again, in a way that Ohio voters didn't intend. And I think some of this also goes to just sort of the practical real world differences between the consumption of alcohol and the consumption of cannabis. So, the idea that, you can give somebody a sip of beer, or you can give them, a bottle of wine for their birthday or something, but you can't go to like a Super Bowl party and share cannabis. I think for a lot of Ohioans, that just seems rather ridiculous.
Good. Representative Williams with the question.
Thank you, Mr. Chairman. So I'm going to try to do this as delicate as possible. I don't know if you were unaware or you were intentionally misleading, but I take it serious when we mislead members of the committee, and especially when we're on public television and we're misleading voters. So when you said that state statute for the social equity jobs program doesn't mention race, I don't know if you're not aware that it does, or you were intentionally deceiving the committee, because it's found in 3780.19 in section B2B1, where in order to be eligible for the program, a member must show, right, sufficient evidence that the business owner has membership in a racial minority group, right, or shows personal disadvantage due to color or ethnic origin or gender or disability. These are the categories that I was mentioning earlier. So when you said that it didn't mention race, it made it seem like I was trying to lie. Mm-hmm. But I was being very truthful that the Social Equities and Jobs Program intentionally tried to give preferential treatment based on race, and the state of Ohio is not allowed to do that. And that's why not a single dollar from the program has ever been given out by the state of Ohio, because we can't follow what the voters voted in because it's unconstitutional.
Through the chair to Representative Williams, my mistake. Thank you for pointing that out. I did not realize race was in there specifically, and thank you for pointing it out on your iPad as well there. So I take full blame for not realizing it. It's never my intention to mislead the committee. That said, does that warrant throwing the entire thing overboard, or can we take that section of the revised code and take out the parts that say race or ethnic identity and continue on with the program. That would seem to me to take care of the concerns that you have.
Follow up?
Thank you, Chairman. So what we propose now is that we have a lot of programs that we fund in the budget. By giving a dedicated portion of taxes that we don't know what it's going to generate year to year, you're putting the state of Ohio in a position of just a pot of money that has to, by mandate, be expended on programs we don't know if they're successful or not, compared to bringing those funds into the general revenue fund where we do allocate them specifically towards those programs.
Mhm.
So we've seen that. The state has invested more and more money into treatment, into rehabilitation, into recovery services. We've seen that time and time again. And there's other portions of this is unconstitutional as well. So the program in its entirety cannot be put into play right now by the state of Ohio because it's unworkable. But as soon as we try to touch any portion of that program, right, it seems as though the Republicans are racist because we want to remove race, when the program in itself had an unconstitutional racial intent that we're not allowed to do here in the state of Ohio. And there's clear precedent outlining that. So that's why there's a push to remove the program and start from scratch. And I'm more than willing to have conversations about what that should look like, whether it should be permanent line items in the budget for certain reentry programs that work towards helping offset some of the economic harm from those convictions in the past.
Through the chair to Representative Williams, I appreciate that, the opportunity for further dialogue and discussion about this. But when you talk about, we'll put this in the general revenue fund, we already fund addiction, we are treatment, we already fund this and that. I don't think anything is wrong with additional funding for that's even a little bit more targeted in the way that voters intended with the passage of issue 2. I don't think that Ohio right now has near the amount of, for instance, treatment funding that it needs. We remain up towards the top in this country of overdoses and overdose deaths. For the last at least 12 years here in Ohio, the number one reason a person goes to an Ohio prison is for the crime of drug possession. We have a lot more to do in that regard. And of course, the Social Equity and Jobs Program would also help fund and advocate for various legislation and enactment of legislation for the purposes of reform and other positive benefits, whether by legislation or otherwise, in a more sort of, comprehensive, holistic way. Including I'm sure could be funding for some of the reform efforts that you support here in the legislature and put into bill form. So it's again, we're at the point here where we're saying via House Bill 160, let's just toss it all overboard. I think we need to have these further discussions with regard to that. But House Bill 160 seems to be on a kind of rocket path through the legislature at this point.
Representative Calendar with a question.
Thank you. Boy, these mics are really different than in the other committee room. It must have made way for the much greater seating capacity. Since we're going down the rabbit hole of the basically the level 3 and some of the other set-asides that were included in the now statutory language that was part of issue 2. And there has been some federal decisions and state decisions in the mediary time that would, in fact, as my learned colleague pointed out, that may strike those provisions of law as being unconstitutional. Your organization seems like it would be uniquely suited and within your traditional role to look to file a declaratory action to have a court declare whether or not those specific clauses have enough nexus to race to be legitimate versus the ones that the courts are throwing out. And it would be helpful to us as legislators and advocates to get an idea of where the courts would land on that, because that is going to be a point of contention. I think just as a fellow attorney, we're at a committee where everybody but one is an attorney, I think. So we're all thinking this, well, there's really strong legal arguments on both sides. Would your organization consider filing a DEC action fairly shortly? So maybe before this bill hits the floor or before conference committee, if there is one, we would all, as decision makers, as law writers, have that data so that we have an indication of where the courts may fall. And I think a lot of us in the room would like to know that answer, but we're not really in the position to file a DEC action, whereas your organization, I believe that's one of your mission statements and one of your founding principles.
Through the chair to Representative Callender, I have learned over the years, never task our litigators with anything, with at least first talking with them about it first. So certainly don't want to do that here today. It brings up an interesting, whether the ACLU of Ohio or anyone, it brings up an interesting point, and one I have to say that I've never previously considered. And that is going to court for a declaratory action for legislation. So what you have is you have something that is not fully baked. It can change at any given time between now and its ultimate passage and enactment into law. So I don't know if you went in there, if a judge would say, look, this isn't ripe. This isn't ripe for consideration because you're just talking about legislation. Now, again, maybe that's happened in the past. I don't know. I'm unfamiliar with the idea of going in for a declaratory action judgment with regard to legislation. So maybe that exists somewhere. I'm not sure, but it's an interesting thought.
Follow-up?
You would not go in for pending legislation. I think you're correct. That's questionable if it's right, but it's existing legislation. It's the current statute.
Right. I see.
And the legislation is looking at potentially changing that or eliminating that as a preventative action from having it thrown out later. So it's tied to it from a practical standpoint, but what you would be asking for a debt judgment on would be the existing statute as passed by the voters, as already in the Ohio Revised Code. You've got a code section to point to and say, this is what we need the declaratory action on. One of the reasons that you could justify is that the funds are currently being held basically in escrow and not distributed under the statute because they're waiting to see legislative or judicial outcome. So you've got the perfect ground and standing to file that action.
Through the chair to Representative Callender, you're absolutely right. It is more than legislation. Of course, it's in current law. And it's something I'll talk over with regard to our litigators, this discussion that came up. Again, ACLU of Ohio is only one organization that could or would file such lawsuits to see what the courts think about this. So, it could be that someone else would do that. It could be that a legislator would do it, if they would be found to have standing to do so. So it's, I'll bring it back to our litigators and see what exactly they say about it. Of course, we could short circuit this entire thing by amending the bill so that current law is amended to take out those very specific race-based parts of the language, and then nobody needs to file a lawsuit anywhere.
Any further questions?
Let's assume that doesn't happen and act accordingly.
Seeing no further questions, thank you for your testimony. Our next witness is Anthony Riley from Ohio Cannabis Live. Welcome to committee. Please proceed when you're ready.
All right. Hello, everyone. Good morning. Thank you, everyone, for being here. I just want to thank the committee for allowing me to testify. I thank all of y'all for putting up with us, listening to us. And after listening to all that, I think we've already started off this hearing much better than the last one I attended, with us all having a conversation. So again, I'm going to go ahead and read my testimony. I aim to just keep it to about 5 minutes. So if there's questions, I'll be happy to take those at the end. Again, hello, everyone. Thank you for allowing me to testify. My name is Anthony D. Riley. I'm the founder of Ohio Cannabis Live and the Ohio Cannabis Expo. I'm a disabled small business owner, and I'm a traumatic brain injury survivor and a longtime advocate for Ohio's cannabis community. My mission is to unite us, all of us, find common ground and strengthen Ohio's legal cannabis program and the community. I'm here to testify in opposition to House Bill 160. Let me outline the main reasons why I oppose this bill. Number one, new penalties for cannabis transportation. These penalties will frustrate voters and continue to push consumers towards, I dare say it, Michigan. I know that's a bad word in here, but we need to say it out loud and stop ignoring it. Where affordable quality products are so-called available. I don't know if I agree with that. Something Ohio struggles to provide right now for various reasons we'll get into later. Number two, employment restrictions. This bill could block people from unemployment benefits. I don't think that Ohio voters want a new situation where they could lose the opportunity to be able to be eligible for unemployment benefits just for being terminated from their job for some type of cannabis related, job related. I do understand about workplace safety, and I respect that 100%. And I think that if we look at Amazon, for example, one of the largest companies in the world, they dropped their cannabis policy completely, and they seem to be operating in the state of Ohio just fine. And they're opening more locations and more drivers are being hired. So I don't think there's an issue with employment that we need to tackle. I haven't heard anyone testify for that. Talking about housing, number three, landlord eviction powers. Allowing landlords to evict tenants over cannabis use risk creating an even bigger housing crisis that Ohio already faces right now. Even in Columbus, we are struggling to find places to build housing, much less why would we want to create a new complication in housing? And this could permanently damage a young person's rental record. Once you get an eviction on your record, it stays on there for years. Many of you already know this. So if someone young were to get in trouble at their college dorm apartment near campus or somewhere else, and the landlord makes it a cannabis issue and evicts them, then this is on their record. This now complicates their ability to relocate somewhere else, not just in Ohio, but anywhere in the country. And I think that's something that the committee should definitely consider. Restrictions on sharing and use. If people can't consume at home because they don't own their house, they're a renter, where do they go? We don't have any consumption facilities available. There's nowhere people feel like there's a designated cannabis consumption place. We obviously all have concerns about using a bar. I know that's something that does happen because where else have we thought about this? We haven't. So I think we need to be looking at consumption parks, consumption lounges, somewhere that is safe, away from children, away from schools, away from churches, away from anything else that could be an issue with the legislator, and allowing these places to be regulated properly, ID checked, security there, law enforcement there, whatever you like. But I do think we need to figure out where cannabis consumers will be able to host events and things of that nature, because this is going to be a huge tourist opportunity that I think the state of Ohio and this committee is overlooking. We could be making way more money than we are now if we start thinking tourism. All these other states around us who have wacky cannabis laws, they're running over here and finding out this stuff's very expensive, and the rules here are so confusing that on a weekly basis, nobody knows how many plants they can grow. Joints definitely don't grow on trees. I grow cannabis myself, and I'm gonna tell you, it's very stressful. It's very complicated when you are a medical patient. I'm suffering from chronic pancreatitis. I suffer from severe pain. I'm on my 13th hospital admission. I literally told my doctors that I wasn't going to the hospital because I had to come here and testify for the people who couldn't be here, that this bill, we need to work together. And I've heard great things. I've heard a lot from the gentleman. He's done a lot of work. I know he has. And thank you again, Mr. Calendar, and all of you for trying to ask the right questions to figure out how we can come together. But we definitely need to come together. I'm having a town hall today at the library around the corner at the Columbus Metropolitan Library, and the auditorium is at 4:30. It's not far from here, but I would love to see any of y'all there just to listen to some of the other people who are suffering from severe pain, people who have found relief in using medical cannabis and quit using opiates, people who are now thinking about quitting drinking and now drinking hemp drinks. Is that the new craze now? We could now see a decline in drunk driving. We could now see a decline in domestic violence. We could see all kinds of things change. And Ohio could be the innovator of all these things instead of us constantly losing to them up north. It's time for Ohio to win, not only in sports, but also in cannabis. We cannot keep letting everybody go to the mega mall in Michigan. It's 30 minutes into the state line. Why don't we have a mega mall here?
Mr. Riley, I'm sorry to interrupt, but you have one more minute.
That's fine. All right. So again, I'll get to the point that y'all want to hear. what are suggestions? Because I heard we need suggestions. We don't need just complaints. We need solutions. So right now, advertising fairness, smoke shops, head shops currently advertising that they are some type of dispensary with no card needed. We definitely need to put something in this bill that prevents this happening. This is a confusion. I don't understand how someone could have a billboard on 23 advertising they are a dispensary when an actual licensed dispensary on 23 actually cannot have a billboard. I do have an example, if you would like that email to you, of that billboard that is advertising that they are a dispensary and they are only a smoke shop. I would love to know how that can work. Hemp product regulations, hemp drinks, as they seem popular now. If you're going to sell them in these other places, as I've heard, we need to ensure that there is proper education for employees about the benefits, the risks, and other things related to cannabis and hemp. Homegrown rights, we need to advocate to keep the count the same. I've heard some concerns about yields. And
Mr. Riley,
yes,
sorry to interrupt. Your time has expired.
okay, all right, that's fine.
Are there any questions from the committee? Representative Calendar with the question.
Yeah, as I said, I'll just kind of consider my hand raised most of the time. I want to thank you for coming and thank you for your advocacy over the years. I see a number of people in the room that have been very on this. And also want to thank you for your compliment as to this committee and this bill and this procedure compared to others. I think you've got a room full of thoughtful people, and I think on both sides. And I think that's going to help us lead to some potential solutions.
Yes, sir.
I brought something with me today I'd like to share with the committee while it's still legal to share. That I ran across the other day, and apparently under this bill I'd be a felon grabbing this in my pocket. But this is to show that there is some common ground. Have you seen something like this? This is Hawaiian Punch, it says, and I'm a trademark lawyer, and it's clearly a violation of trademark. It literally is the Hawaiian Punch logo.
Right.
1,000 milligrams of THC, 96.1% THC, 0.54% CBD. No ID required to purchase, no ID required to go into the location. And I guess one of my questions for you, since you brought it up with the clearly erroneous and incorrect advertising, is there anybody in this room, and I'm going to ask the advocates a question and the members, that thinks this is okay? You think this is okay?
Could you tell me what kind of THCA that is? If
No,
THCA,
because it's not labeled. It just says THC.
It would be a simple way to fix that.
But that gets to the whole point of labeling, right?
Correct.
So is there anybody that thinks this is okay?
Where did you purchase it from?
Someplace in Ohio. I'm not going to out them because they're in my
Was it a
district, but
dispensary?
it was clearly not a dispensary.
Okay. No, that's.
So my question to you is, and to all the advocates, I think, is can we help stress the common ground we have here and the things that we need to look at? Because you'll have your chance to testify, I'm sure. That's up to the chair to regulate. And he's been generous to let me go further than he should have.
Excuse me, Mr. Chair, may I
So
respond?
thank you. But I wanted to, at some point, bring this out as the common ground that we all have. We don't want children having access. We don't want false labeling. We don't want really no labeling. We don't write outrageous claims like that you're a dispensary when you're not, or that it's THC without labeling what that means exactly, because we all know there's a lot of things that can be that and I find the claim dubious as to the actual content. But I think I just mainly wanted to thank you for coming in and agreeing that there is common ground and things in this bill that are good, and that let's build on those commonalities and see if we can limit the bill to those.
Chair, through to Mr. Calendar, Representative Calendar, thank you again for your kind words, sir. And to directly respond to the package that you said, I do agree that this has really gotten out of hand, that we don't have any way to do some type of compliance with these products that are being sold outside of dispensaries. And again, this leads to the division we have in the hemp and cannabis industry right now, and all the confusion about what exactly is legal and what's not. So again, thank you for bringing an example. I wish I would have had the courage to pull something like that out, but of course you here and you could do that. I don't want to get escorted out here by State Highway Patrol, so I would not do that. But thank you for bringing that to us, showing us that these things, we need to address this. There is urgency in getting something done together, and that's why I'm hoping that we can work together.
Great. Representative Mohammed with
Yeah,
a question.
Thank you very much, Chair. Not really a question, but more so a comment. Thank you, Mr. Wiley, for your testimony. Thank you for your advocacy. Thank you for coming with everything that you're dealing with. For you to be here and advocate for the folks means a lot to the people. And I will definitely be at the town hall, and I urge members of this committee and others to also show up and actually speak to the voters and hear what you're dealing with and what your interests are, because ultimately I think we're losing sight of that. So thank you very much.
Thank you. And I will not let anyone get yelled at. I don't do that. Thank you.
Thank you for your testimony. Our next witness is Lexi Lawson from the Anderson Township Board of Trustees. And ladies and gentlemen, we're going to limit your testimony to 3 minutes. And if there are questions from the committee, then we can proceed from there.
Thank you. Chairman Thomas, Vice Chair Matthews, Ranking Member Isaacson, and honorable members of the House Judiciary Committee. So my name is Lexi Lawson, and I serve as Chair of the Anderson Township Board of Trustees. It is my honor to appear before you today on behalf of the Board of Trustees to offer testimony on House Bill 160, specific to the section which modifies the distribution of adult use marijuana excise tax. So Anderson Township is an urban community of over 44,000 residents located in Hamilton County in Southwest Ohio. The township is bounded by the Ohio River to its south and the city of Cincinnati to the west, with several villages and townships comprising the remaining borders. We are a full-service township maintaining 122 miles of roadway and responding to 15,678 calls for fire, emergency medical, and law enforcement through 2024. Yet we remain to the township form of government with 84.4% of our revenue derived from property taxes and tax increment financing. So in 2023, we saw an opportunity to lessen the property tax burden for our residents and businesses with the passage of State Issue 2, which stipulated that a portion of the taxes collected on the sales of adult use cannabis be distributed to host communities. Anderson voters in each of its 32 precincts overwhelmingly supported the commercialization, regulation, legalization, and taxing of adult use cannabis. In keeping with the will of our constituents, the Board of Trustees permitted dispensaries to locate within our community with the expectation that we would receive approximately $1.5 million in host community fees annually. That revenue would be used to support our diminished general fund, which has experienced significant reductions since 2011, and would allow us to stretch existing property tax levies, thereby reducing the property tax burden on our taxpayers. For example, prior to its elimination in 2013, Anderson Township received an average of $1.7 million annually from the estate tax. This, combined with the redirection of commercial activity tax revenue to the state's general revenue fund, the elimination of public utility tax, and changes in the local government fund formula, resulted in Anderson Township losing almost $7 million in general fund revenue in 6 years. Some relief was anticipated with the advent of video lottery terminals at Ohio's 7 horse racing facilities and the promise of an annual host community fee of $500,000 from the Casino Operator Settlement Fund. However, after receiving 4 initial payments totaling $2 million, that revenue stream was eliminated through legislation during the 129th General Assembly. It is our hope that the host community fee associated with adult use cannabis will not face the same fate. Those who voted in favor of Issue 2 and local government officials who chose to allow dispensaries in their communities did so with the understanding that they would receive 36% of the 10% tax levied on the sale of adult use cannabis. This funding was slated to support communities who have adult use dispensaries in their jurisdiction. We respectfully ask you to ensure that funding for host communities, as was originally approved by voters, is included in House Bill 106. Again, I thank you for the opportunity to discuss this and to address this honorable committee, and I welcome and appreciate your questions.
Ms. Lawson, thank you for your testimony. Are there any questions? Representative Stewart with a question.
Thank you, Mr. Chairman, and thank you for your testimony. When issue 2 was on the ballot, a lot of the discussion of the host community money was about there may be costs that local governments incur. Might turn up. Can you hear me? Sorry. Yeah. Okay. Discussion about increased potential costs for local government that we may have as kind of being the rationale for this money. Since September of 2024, when this started being sold, can you quantify, I mean, has the township incurred additional costs to respond directly to the handful of dispensaries that have been authorized?
Through the chair to Representative Stewart, respectfully, I do disagree in that the money, the intention in those discussions, I know that I personally had with residents, was not necessarily related to policing the facilities. Locally, we are very close with our residents and able to have those very in-depth discussions, and our residents were extremely informed. And so their expectation for us as township trustees has been a very specific mandate to reduce the property tax burden. And so, for example, we just passed a public safety levy. It was challenging to do so. We contract our own police department through the Hamilton County Sheriff's Office. And so there are additional needs and specific needs to our community that our community is looking for us to address, give them reprieve on that without increasing taxes. So as trustees, we were looking at this from a completely different angle. We looked at that verbiage very literally, and that it could be used for communities in general. But mostly for our angle, it was supporting our residents with reducing their property taxes.
Follow up. So putting aside what I guess your residents did or didn't believe this money was for, have you had any increased costs as the township to respond to the presence of these dispensaries?
So the residents' comments to me as an elected official were based on the ballot lingo. And so we have new 2 dispensaries that just opened. One that was given to us by the Ohio Board of Pharmacy, even though we had put a ban and only asking for 2. These businesses are not fully operational. We are seeing other businesses, as was mentioned by a previous representative, such as nicotine sales. So those are the increased calls that we are getting, selling some of these products and concerns and investigations. And so that is the type of revenue that residents are looking for us to deal with those issues without increasing property taxes and levying for our share of services sooner than we have in the past.
Representative Mohammed with a question.
Thank you very much, Mr. Chairman. Thank you very much for your testimony. And I appreciate you coming down and speaking about what your constituents talked to you about. And we also met with a lot of our constituents, and they also had a similar expectation as well. I think, again, we're losing sight of the fact that of what voters wanted. This is what they expected when they voted for issue 2. So thank you for your testimony. Appreciate that.
Thank you.
Any additional questions for the witness? Seeing none, thank you for your testimony.
Thank you.
Our next witness would be Kristen Mullins from the Ohio Grocer Association. Welcome. When you are ready, please proceed.
My testimony is very short, so I'll go
right.
very quickly. Chair Thomas, Vice Chair Matthews, Ranking Member Isaacson, and members of the House Judiciary Committee, thank you for the opportunity to provide comments on hemp-related provisions in House Bill 160. As president of the Ohio Grocers Association, I proudly represent food retail, wholesale, and supply members across the Buckeye State. My members include the smallest mom and pop stores, independent grocers, and some of the convenience stores, and of course, the wholesalers and suppliers who supply those stores. We share the legislature's concern on making sure adult use products are kept out of the hands of our children. Our members have extensive experience and take responsibility for selling a wide range of these products to Ohioans on a daily basis. These are rigid protocols and enforcement mechanisms to ensure that any adult use product is only sold to the age-appropriate consumer. However, we have concerns that the language in Senate Bill 160 would ban most types of illegal hemp products from retail sales, reducing access to consumers. We instead urge the House and welcome an approach that addresses youth access by incorporating strict regulatory oversight. These include components such as age-restricting products, product labeling, rigid testing procedures, and other regulatory requirements. We believe this is the best approach to not harm legitimate Ohio businesses like my grocery stores while retaining proper limitations and safety measures. We do look forward to continuing the work of this committee on this legislation as we move forward. Thank you. Thank you.
Great. Thank you for your testimony. Any questions for the witness? Seeing none, thank you for your testimony. Our next witness is Leslie Bryant. Welcome, Mr. Bryant.
Thank you.
Yeah, we have 3 minutes.
All right. Chair Thomas, Vice Chair Matthews, Ranking Members Isaacson, and members of the Judiciary Committee, thank you for the opportunity to provide opponent testimony on the HB 160 this morning. My name is Wesley Bryant. I'm the founder and CEO of 420 Craft Beverages, a Cleveland-based hemp manufacturing company specializing in infused drinkable cannabinoid products distributed across Ohio. This bill in its current form strips federally compliant hemp businesses of their rights, forces them into federally illegal commerce, and rigs Ohio's cannabis market in favor of few larger players. It violates multiple federal protections and should be rejected outright or fundamentally amended. Now, I'm going to start this off by saying you guys are all lawyers, but this is my understanding from my law group. The legal conflicts and federal law violations, supremacy clause violation, criminalize, restrict federally legal hemp-derived products unless they are sold through marijuana dispensaries. This violates 2018 Farm Bill, which federally legalized hemp and protects interstate commerce in those products. Also, the Dormant Commerce Clause violation. HB 160 discriminates against out-of-state businesses requiring all sales of hemp-derived products to be routed through Ohio-based dispensary. This restricts lawful interstate commerce and creates unconstitutional and economic protectionism. Now, this one here is the scariest one for me. HB 160 mandates that hemp businesses sell only through federally illegal marijuana dispensaries. Accepting proceeds from dispensaries may constitute federal money laundering, even if the product is legal. This exposes hemp companies to criminal liability and forces them into legal jeopardy for simply conducting lawful commerce. Number 4, USDA and DEA jurisdiction conflict under federal law. Hemp and derivatives are regulated by the USDA. HB 160 places control of hemp-derived products into the hands of Ohio Division of Cannabis Control, which is authorized only to oversee marijuana. This contradicts 2018 Farm Bill and improperly overrides federal regulatory authority. This is also a pretty scary one because I hold multiple trademarks. This would be the trademark and contract enforcement risk. Federal courts cannot enforce contracts involving federally illegal activity. Tying hemp-derived products to marijuana dispensaries makes it impossible for hemp companies to protect trademarks to the USPTO, enforce contracts in federal court, and secure insurance or federal loans. Finally, number 6, unconstitutional conditions doctrine. HB 160 conditions legal commerce in hemp on forfeiting the right to sell outside a marijuana system. Courts have held that states cannot force businesses to surrender federal rights in order to comply with state law. HB 160, this is the key policy failure that I came up with. HB 160 in its current form creates monopolistic market by routing all hemp products through marijuana dispensaries. The bill consolidates power in a small group of vertically integrated operators, destroying fair market competition and access for small businesses and consumers. HB 160 would result in products with less intoxicating effects than alcohol or marijuana are banned from general retail.
Mr. Bryant.
Yes.
Your time has expired.
Oh, darn. I got just a tad bit more.
Thank you. Now, are there any questions from the witnesses? I'm sorry, I don't have any questions for the witness. Seeing none, we thank you for your testimony.
All right. Great, guys. Thank you.
Next is JJ Coombs from Alpha Brands. provide opponent testimony. Welcome. Please proceed when you're ready.
Good morning, Chair Thomas, Vice Chair Matthews, Ranking Member Isaacson, and all the members of the House Judiciary Committee. My name is JJ Coombs. I'm the CEO of Alpha Brands, Arvita Labs, and Mello Fellow. I hold a doctorate in pharmaceutical sciences. I hold a PharmD, and I have extensive experience in the hemp industry, including product formulations, manufacturing, and ensuring compliance and rigorous health and safety standards. Throughout my career, I've collaborated closely with state and federal regulators, policymakers, and industry leaders to advocate for sensible and effective regulations. The 2018 Farm Bill, which federally legalized hemp production, opened significant opportunities for American entrepreneurs and created a burgeoning market for innovative products, while simultaneously promoting economic growth and public safety. I typically advocate for minimal taxation and regulation. However, in this instance, I'm advocating for clear and sensible regulation. Ohio businesses in the hemp industry require precise guidelines to ensure compliance and promote legitimate operations, ultimately protecting consumers and fostering economic stability. HB 160 raises significant concerns for our industry. If passed, it would negatively impact thousands of small Ohio businesses, inadvertently strengthening the illicit market actors who exploit regulatory gaps and threaten consumer safety. This bill in its current form does not eliminate consumer demand. It merely pushes it towards the unregulated channels. In Ohio alone, the hemp-derived cannabinoid industry contributes roughly $700 million annually to the economy and employs over 8,000 people, provides approximately $327 million in wages, and generates more than $40 million in sales tax revenue. At Alpha Brands, Arvita Labs, and Mello, we adhere to the highest standards of safety and transparency. We implement rigorous practices, including thorough batch testing, comprehensive full panel testing, meticulous chain of custody procedures, complete product traceability, and also good packaging requirements. We advocate for regulations that specifically target bad actors without harming legitimate Ohio businesses. Sensible, targeted legislation can effectively address industry issues, enhance consumer safety, and eliminate harmful practices without devastating economic impacts. In Virginia, overly restrictive laws decimated the legal industry overnight, inadvertently fueling black market operations. Conversely, states like my state, like Florida, Tennessee, Georgia, and North Carolina, have opted for thoughtful, balanced regulatory framework that protect Ohio consumers and legitimate businesses alike, which could serve as beneficial models for Ohio. We respectfully request this committee carefully consider the economic and safety implications of HB 160 and instead support sensible regulations included in HB 198 that protect Ohio consumers, support responsible business practices, and ensure sustainable growth of this important federally legal industry. Thank you again for this opportunity. I'm available for questions.
And thank you for your testimony. Are there any questions for the witness? Seeing none.
Thank you.
Thank you for your testimony. Our next witness is Rodney Hennessy. Welcome.
Thank you.
Please proceed when you're ready.
All right, and I will apologize because this will take just a little over 3 minutes, but I did drive in from Cleveland, so.
Okay, you've got 3.
So Chairman, Vice Chair, Ranking Member, and members of the committee. Today, I would like to thank you for speaking and the opportunity to speak in opposition to House Bill 160 and all other related bills that undermine Issue 2. Issue 2, which Ohio voters overwhelmingly passed to legalize cannabis. The people spoke very loudly. My name is Rodney Hennessy, but most people know me as the educator Rodney Hash. I've worked across every part of the cannabis industry, legal and illegal, through the cultivation, through extraction, all the way to retail. And I now help lead the Ohio Cannabis Consumer Coalition, and as such, I represent voters from both sides of the aisle across the state. We ask for progress, not more prohibition. This is not a partisan issue. It should not be. Issue 2 was a strong compromise for decriminalization, jobs, and social equity. Bills like House Bill 160 roll back our rights, protect monopolistic interests, and hurt the vulnerable, our elderly, our farmers, and our communities. Why are you trying to rewrite the will of the people? First, these bills harm elderly and medical patients. By limiting licensing and allowing overpriced, nearly expired medical products to then be sold as recreational use products, you drive up costs. The old lady on Social Security that has knee pain cannot afford to drive to the Michigan market, nor can she afford to drive to the dispensary here in Ohio. Because if she was to buy something, she could only buy enough for a couple of days, and that wouldn't get her by through the month, and we know it. A caregiver program and open licensing process would allow for lower prices and help patients, not the black market, as some say. Second, these bills hurt farmers. Hemp is already a regulated crop in the state of Ohio. It would create jobs and help. It could potentially clean up areas like East Palestine. We use it to clean up nuclear waste sites. Why couldn't we use it to clean up East Palestine? Bless you. Instead, you're stifling innovation with vague laws that confuse safe THCA hemp with synthetic cannabinoids like the one Representative Caliver brought up, which I would love to talk more on. Bless you. If you're truly concerned about the kids, you would implement a age restriction, just like we do alcohol and tobacco. But instead, we're trying to ban it all together. Now, I don't agree with the synthetic cannabinoids, but safe THCA flower should be sold. We have Appalachian grows in the state of Ohio. There's plenty of people that are legal operators. Third, do you guys think Ohio voters are stupid? Because the senator from my district, Jerry Serino, implied as much on April 17th when he outright said it. Ohio voters read and supported issue 2 as it was written. By the way, no experts, if you guys are truly consulting them, would ever measure cannabis by the joint. Us experts measure it by, in the legal industry, because of square footage, we measure by grams per square foot, or we measure grams per ounces, or grams per plant, if we're talking the home growing version of it. Finally, why would you block economic growth and social equity? Social equity is not the same thing as DEI politics. I get that. But social equity's funds sit unused when they could be used to expunge records. They could be used to create jobs. They could be used to support local libraries and school districts that are currently facing monies being cut from them. We could be helping the communities and the children, but instead we're just sitting here making it illegal again, making it a crime for me to be able to share a joint with this man right here. That shouldn't be. That's not what the community agreed upon. I'm tired of being labeled a criminal. Voters demand new licenses, farmer-friendly rules, an end to prohibition. The federal government just pardoned Ross Ulbricht, the guy who created the Silk Road, but yet Ohio's sitting here threatening to prosecute someone for passing a joint. I would like to open up the floor to, first off, thank every single one of you who has been asking questions on this. It is really important to all of us. I would also like to extend the hand and thank to all of those representatives who have also, we've been reaching out. This gentleman right here has been reaching out to every single representative across the state. And we have gotten a few handful of you guys who have been asking questions and wanting to work with us. And I truly do appreciate that. If you guys have any more questions, again, I represent the Ohio Cannabis Consumer Coalition, and we're open to any and all feedback.
Thank you for your testimony. Are there any questions for the witness? Representative Mohammed.
Thank you very much, Mr. Chairman. Thank you, Mr. Hennessy, for your testimony. I think your testimony can be boiled down to 3 main things: decriminalization, jobs, social equity. I think you said it perfectly. Thank you for your testimony. I'll reiterate again that I will be at the town hall. I'm hoping more and more members of this committee will be there as well. Thank you.
Representative Sonnenberg with a question.
Yes, Mr. Hennessy, thanks for your time and for coming in today and making the trip down from Cleveland. Just from a brief, like scientifically standpoint, how you said hemp could clean, that's your nickname, sorry. How does growing hemp clean up like an area that's like East Palestine that has contamination?
So we know a lot of the issue with East Palestine is the chemicals that are in the ground. As I elaborated on a little bit before, we actually use cannabis or hemp, which is the same plant, by the way. We use that to clean up nuclear waste sites because it's so beneficial at pulling up all those other micro contaminants in the soil, which is also why I will say certain testing does matter. Things like contaminants could be coming up from the ground, it could be in the plant, but that's why we use that as industrial hemp rather than using it as something we could sell to the public.
Follow up?
Yes, follow up. Thank you, Mr. Chairman. Would you agree that issue 2 as passed, well, although the will of the voters, still there are aspects of it that could be cleaned up and changed by this body? And are there, I'll leave it at that.
I would agree that there could be compromises, but I think issue 2 as it stands is a good bill. I think issue 2 as it stands, when you start looking at it in comparison to other states that have both adult use, recreational, which for some reason in the regulations that we have currently, that's not allowed to be said. in the dispensary. You have to say adult use, not recreational. I think there's compromises that could be made, but generally speaking, I think that issue 2 is pretty middle of the road for most states that have both recreational and medical.
One follow-up, yes. On hemp, though, you do agree, I think, according to your testimony, that the synthetic
Yes.
is something that should be regulated by the state.
So I would argue synthetic, along with certain remediation processes within the legal market, should be addressed. And that's where I feel like we should be going in with experts, education, and a scalpel rather than a guy with a lumberjack and a chainsaw and just nuking it all. We should be going in and, like, for example, the HHC molecule, I don't really think that's great. Delta 8 and Delta 10, I don't think those are great. But I also think like CRC remediation forms are not great, and that's legal. But that's something because of the fact that there's a lack of education across the legislature and the ruling body, that rather than consulting with experts like those of us at the coalition, Appalachian Girls, we've got the Cannabis Museum here in Athens, Ohio. But none of these guys get reached out to by the DCC or the Board of Pharmacy or anyone really.
Thank you again. Thank you.
Any other questions for the witness? Seeing none, we thank you for your testimony.
Thank you. I appreciate you guys' time.
Our next witness is Joey Elwood. Mr. Elwood, welcome to committee.
Chairman Thomas, Vice Chair Matthews, Ranking Member Isaacson, and members of the committee, thank you for the opportunity to provide opposing testimony to House Bill 160. My name's Joey Elwood. I'm with Appalachian Girls and Modern Remedies. I'm one of 33 hemp farms left here in the state of Ohio, uniquely positioned in that we cultivate hemp outdoors. My partner, Matt Osler, cultivates indoors. So we're the farmers. We also are entering the adult use space, and we now have drinks. So I'm here to talk about 3 main issues or challenges I have with this bill. One, I read this a long time ago. There's 4 bills in motion, so a lot to digest as somebody who's got a day job as well. One, I'd like to amend the milligram amount. 2, I'd like to request some language barriers that are put up in this that separate hemp farmers from cannabis. And 3, I'd like to think about priority access as it relates to hemp farmers growing cannabis outside. So starting out lines 427 through 430, let's move that up at least to 10 milligrams per package or per serving, 100 milligrams per package. I have 2 different brands, 2 different products, probably 3 or 4 if I really think about it, that don't get people high, would be illegal if this went through, and they help people. These folks are actually using these products so they don't like to get high, but they have stress, sleep, anxiety issues. There's no consideration for cannabinoid ratios in this bill. I'd like us to look at that. Our team at Appalachian Girls held out for some time. Appalachian Honest is a tagline of ours. So we held out for some time in the drink space and all this other places. But what we realized is that there's large brands with lots of like war chest money. They could go out and start another brand. And I think Mr. Bryant said it earlier, you can't stop interstate commerce. So the laws we're putting in place with this would take away jobs from self-employed Ohioans or other folks, whereby they would just send it in via internet sales and trust that an age gate would work. The third, I'm getting the look. So the third point would be remove lines 547 through 549, as well as 587 through 594. These just simply say like hemp farmers can't grow marijuana. I would look to remove that language and potentially amend. And if we'll just go to the third point, let's look at states like New York, whereby they let hemp farmers have dual licenses. Section 68C in their language allows hemp farmers to participate outside. The sun's free. We want to use it here. Ohio is getting our pants whipped off us by the state up north. I think the gummies up there are like 7 times less expensive because they're using the sun. Indoor cultivation costs 10 times as much to grow. I would just ask for your consideration on this. I'm probably out of time. Thank you so much for the opportunity, and I'm available for any questions.
You had mentioned New York. From your experience, is there a state from your experience, is there a state whose overall cannabis hemp program is one that is a model?
Through the chair to the representative. No, sir, there's not a panacea out there. This is the rebirth of an industry. The Ways and Means Committee 100 years ago slid through the Marijuana Tax Act, and we didn't have a lot of deliberation at that time. I would think that we should unpack this. There's 16 other states, I believe, growing outside right now. I think that's table stakes for us here in Ohio if we want to compete. My partner Josh at Appalachian Girls says sustainability is not just ecologically, it's economically too. And us as a bootstrap company, we need to be able to grow outdoors. It's 10 times less expensive. And there's certainly states that are doing that and practicing it well. But to your point around New York, it has some good laws, and I would love that we looked at that as it relates to the hemp farmers. Oregon is another one that's a bellwether state as it relates to hemp and cannabis working together. That's it. Thank you.
Thank you very much.
Thank you. Any other questions for the witness? Seeing none, thank you for your testimony.
Thank you.
The next witness is Joshua Crocier. Welcome. Please proceed when you're ready.
I am super blessed and appreciative to be up here right now. So I wanted you guys all to know that. The fact that we're finally opening up discussions about this plant and having meaningful conversations is a step in the right direction. So thank you to every one of you. I'm Josh Crozier, and I will make this as quick as I can and talk as quick as I can. I'm Josh Crozier. I got an associate's degree in natural resources management from Hocking College. I got an environmental science degree from the University of Rio Grande, and I got a master's degree in sustainable agriculture from Ohio University. I'm an advisor to the Cannabis History Museum, and I've now went full circle to now where I teach the cannabis history program at Hocking College. So I'm very excited about cannabis. Okay, everybody's given you some statistics and certain points of the bill, so I won't take a lot with that. I'll just let you know how I feel about this morally, right? Just to sum it up, no public use, no travel, eviction notices. This is exactly how I would write something if I wanted to continue to keep minorities and poor people in jail. Absolutely unnecessary. The irony of a bill that attempts to expunge things while simultaneously creating new criminal offenses. That's literally unreal, right? We did not vote on getting our temperature checked the old way, right? We voted on issue 2, and it's very obvious what we expected when we got that. So I won't take up more time. One more push I want to make about 160 is the tier 3, right? Like the fact that you're hesitating this is exactly why you're not meeting the cannabis culture where it is, right? People want access to high quality craft cannabis. So the excuse of, okay, we're going to do this in 2 or 3 years so that these guys get all their money back, to me, I find appalling. We don't wait until Walmarts get paid off before mom and pop grocery shops can start popping back up. This just limits things, it restricts things, and it doesn't give the consumer the high-end, organoleptic, terpene-full, minor cannabinoid-full, full experience cannabis products that we actually want, right? If we can afford it, we should be able to buy that high-end stuff. I'll touch on Hemp Bill 189 because I didn't want to take up your time twice and testify on that as well. I also think we're missing the argument with this entirely, right? Like, look at all the money and opportunity it can bring. However, our agricultural systems have no place in this. Because of however this was wrote up in Ohio by whoever, I don't understand why, it's a total THC state. So all of these products, from the drinks to the vape store, anything that people are going in to buy where you think, oh, hemp is really booming right now. Our agricultural systems are getting hit the hardest because we can't contribute into this operation. It's absolutely absurd. Ohio hemp farmers need to be prioritized in any moves made in this industry. Combining a federally legal product into a federally illegal state program, I don't think that's the way to go either. So thank you for hearing me out. I appreciate all your times. Are there any questions?
Are there any questions for the witness?
Thank you.
Seeing none, thank you for your testimony. Our next witness is Sarah Coya Bryant. Welcome. When you're ready, please proceed.
Thank you, Representative Thomas, committee members. I have a garden supply store in Athens, Ohio. We're a specialty garden. We have LED lights, equipment for indoor gardens, and for specialty plants. We in Athens helped with campaigning for issue 2. We were very clear about what was being outlined in this law. I find it rather reprehensible that people who are paid to represent us instead just say that we don't know what we're voting for and that we're not smart enough to understand what we were voting for, because that's not true. It's very far from the truth. Ohioans study this law very well, and we have been looking forward to opportunities of things like the Tier 3 licensing. I live in Athens County. We're one of the poorest counties in Ohio. We had no chance of getting anything out of the original medical program because no one has, $50,000 to apply or even $15,000 to apply. So we were well aware that Tier 3 was going to offer opportunities to poor and disadvantaged Ohioans. We were also well aware that Tier 3 was going to decriminalize activities like sharing our cannabis with one another. And I can tell you from my customers that have been very enthusiastic to do that. And the idea that we will suddenly be criminals, that we will have to spend 3 days in jail if we have our home grow in our car is outrageous. I went to a meeting with my county commissioners and tried to explain to them that we're going to have money coming out of our budget to keep me in jail for 3 days if I have my home grow in my car. I'm a business owner. No one should be in jail for cannabis. Ohio voted that we are not going to jail for cannabis anymore. So you guys need to look closely, if you haven't already, at these little nuances in this language, because it's very damning and it is very far from what those that you are paid to represent expected from you. I understand that you're lawmakers, that you can make and you can modify the law, but the law that we put in front of you as citizens is very close to what we expect it to be, and any thwarting of that and recriminalizing it, it's nefarious behavior, and all of us out here just really kind of wonder why. There's been no uptick in crime because cannabis users already existed in Ohio, and we came out in mass to support this bill. And the fact that you guys aren't giving our cities our tax money and you want to redirect it to the general fund, that's also outrageous. Our county commissioners, they are going to have to pay more money, and then our municipalities aren't getting the money from our dispensary we already have. Why? Who can tell me why?
You finished?
Yes, sir.
All right.
I was waiting.
All right. Representative Plummer with a question.
Well, thanks, Chairman. Hey, I live in Dayton, Ohio. Welcome.
Yeah.
Welcome.
Thank you.
So quite a few people are driving high in Dayton. You can smell people in front of you smoking weed while they're driving. Do they do that in Athens?
I haven't noticed it.
So we all want to discuss no criminal penalties. I think there should be a criminal penalty for driving high, kind of like driving drunk. So there could be a criminal element to cannabis. Is that a fair statement?
So if someone is intoxicating while they're driving, be it their Xanax prescription or whatever it is, I think that we can all agree that we don't want people intoxicated driving, sir, because that's not safe.
So we agree there could be a criminal element to cannabis, because we're
Yeah.
hearing shouldn't be a criminal element because the voters didn't vote for a criminal element. But there are certain areas where there could be a criminal element. Just so
So
I'm straight.
If you have an unopened bottle of wine in your car, you don't go to jail for 3 days. You know, there's a difference between drinking wine in my car or just having an unopened bottle, right? If there's nobody smoking cannabis in a car, how can you say that that should be criminalized? Because possession of cannabis is not a crime.
Follow up?
But sticking to the basic question,
Uh-huh.
smoking while driving and you're high can be criminal. I don't care about an unopened or open bottle of wine. We're just talking to driving while high should be
Okay.
criminal. That's the question.
So is that what the language says, or does the language say any home grow in your car, you go to jail? Because that's what's concerning to me. I agree that people should be not driving their car while intoxicated in any manner. But, you know, if someone's carrying their home grow, that they voted that they should be able to have their 2.5 ounces out of the house to take to, let's say, their sick friend or cancer patient, no, that should not be criminalized in the car.
Any other questions to witness? Seeing none, thank you for your testimony.
Thank you.
Our next witness is Karen O'Keefe. Welcome.
Good morning. My name is Karen O'Keefe. I'm an attorney and the Director of State Policies at the nonprofit Marijuana Policy Project. We strongly urge you to respect the will of the voters and to reject HB 160 or to significantly amend it. As Derek Klinger argues in his forthcoming law journal, which I linked to in my written testimony, HB 160's prohibitions may well violate Ohio Constitution's anti-subversion clause. The Ohio Senate disapproved of voters' decisions to legalize cannabis. They passed a resolution just a couple of weeks before the vote and by an overwhelming margin. Voters chose to legalize cannabis anyways. Both in SB 56 and the provisions that carry over into HB 160, there is an overwhelming theme of undermining that decision to legalize adult use conduct with cannabis. It has so many exceptions that they swallow the rule. Turning to specifics, HB 160 removes issue 2's language that legalizes the use of cannabis. That needs to be restored. HB 160 also removes issue 2's language that legalizes adults' transfer of cannabis. That would be as ridiculous as prohibiting sharing Tylenol, a bottle of wine, or homebrewed beer. That also needs to be restored, whether it's homegrown or otherwise. Next, the definition of adult use cannabis needs to be restored so that the bill no longer prohibits having cannabis that came from another state or somewhere else. There are over 200 million visitors to Ohio every year. Every one of them who has legal cannabis with them would be a criminal if HB 160 passes as is. Crossing state lines with cannabis is no more federally illegal than it is to possess cannabis. This provision would result in intrusive interrogations as to where people obtain their cannabis, demands for receipts, and an overall air of suspicion. There is no similar prohibition for any other legal product, including alcohol that's purchased from another state or not from a legal state store. We also strongly object to the language that only allows smoking and vaping in residential or agricultural places. There are thousands of places in Ohio where you can drink alcohol outside of your home, and you can smoke cigarettes in many places, including outdoors and in some specified hotel rooms. Businesses should be allowed to permit the consumption of the combustion of cannabis in outdoor locations and indoor ones, such as specific hotel rooms where smoking is allowed and adult use patios. Without it, there's nowhere for visitors or for tenants who are not allowed to smoke at home to use cannabis. We also strongly object to the language allowing landlords to penalize vaping of cannabis in their rental homes. Issue 2 already prohibits smoking in a rental home. If a landlord prohibits it, this goes too far. There is not the kind of odor that you have with smoking with just vaporizing cannabis. We also strongly object to the so-called open container rule that prohibits having cannabis transported unless it's in a trunk or similar location or unopened original packing. Unlike beer cans and wine, packages of cannabis often have a week or more supply of edibles and flour. The open container provision is onerous and impractical, especially for disabled people, and it's not even really possible if you're in a ride share or public transportation. I also have additional concerns, which I've outlined in my written testimony. The last thing I wanted to address orally was the issue of allocations. We urge you to restore the funding from issue 2. The part that goes to the social equity and jobs program can be used for a very wide number of things, including things related to the industry and having an equitable industry. It also includes things like community reinvestment, violence prevention, and expungement. It's essential that this be restored. For example, some of the funding could be used to eliminate all fees for cannabis expungement, to support legal assistance with this expungement, and to have funding for local prosecutors to be able to have locally initiated expungement, which was authorized by the Ohio legislature a few years ago, but I believe is not funded by the state. In closing, as the Ohio Supreme Court said, Ohio's initiative process is one of the most essential safeguards to representative government. Passing a bill that is a death by 1,000 cuts is an affront to voters. Respecting the democratic will of voters may well be constitutionally mandated, and it could result in litigation if there are attempts to recriminalize or otherwise undermine that. It is definitely the right thing to do. Thank you for the opportunity to address you.
Great, thank you. Are there any questions for the witness? Representative Calendar's question.
Same question I asked of the ACLU earlier. Is it possible for you to put together kind of in priority? I know you've got your testimony that kind of includes it, but specific amendment language that would address some of the issues that you had. The call for amendments is very short. So I'd ask that if you could do that, provide it to the chair for him to distribute to us to look at. That would be really helpful.
Sure. Just to clarify, you want amendments, how I would amend HB 160, not how I would amend issue 2, right?
Correct.
Sure.
Thank you.
You're welcome.
Representative Timms with a question.
This is the one. To the chair, thank you for being here today in your testimony. I'm reading here. You have on bullet point 4, restore the definition of adult use cannabis, so House Bill 160 no longer bans marijuana purchase in other states or of unknown origin, and so non-discrimination protections are not contingent on proving the source of cannabis. Can you, I guess, give us a scenario where that could happen in terms of a driver being pulled over or someone being required to prove the origin of the packaging of the marijuana?
Yeah, so there's two different things. For the criminal aspect, as it's written, it would be illegal to transport any cannabis that isn't adult use marijuana, which appears to be defined as marijuana from Ohio retailers. So in practice, if somebody's driving down the street, they have, say the ACLU has these got a warrant jars. If they had their cannabis in one of those, then in addition to being an open container, they could be charged with a minor misdemeanor because they can't prove that they got it from a store. They might have grown it on their own. So you could end up with a lengthy interrogation. Where's your receipt? Prove that you got it from there. Or you could be passing through from another state like Michigan and have cannabis that was from a store that's only in Michigan, not in another state. Either way, you could end up with law enforcement interrogating you, finding out where the cannabis is, and then you end up with a minor misdemeanor and that criminal record as a result of it. And then there's the non-discrimination provision. So HB 160 totally repeals the non-discrimination language that is in issue 2, which says you can't lose your children for the responsible use of cannabis, you can't be denied medical care or organ transplants. There's a long list of things. It instead inserts that in the existing medical marijuana non-discrimination, which is more limited and uses the term adult use cannabis. So theoretically, the only way you are protected from any of those things, losing your children, losing your professional license, which it also restricts, so it's only not use, but that's a different issue. You could theoretically have to prove to not lose your children that your cannabis was obtained from Ohio retailers. So there's no reason to add that burden. It just trips people up and makes it harder to exercise your rights and limits the scope of legalization.
Oh.
Thanks, Chair. And I asked that question because some people who know me know that I love Beyonce, and my dear friend Red Plummer knows I love bourbon. And so my favorite artist came out with her own whiskey, but unfortunately it was not sold in Ohio, and so I would have to travel to another state in order to bring that back home, and I would not be subject to the same criminal penalties as is written in House Bill 60, correct?
Correct. And no other state does that as well for alcohol or cannabis. Sorry.
Representative Mohammed with a question.
Thank you, Mr. Chairman. Thank you very much for your testimony. I did want to ask, And this is a question that my colleague Rep. Timms brought up as well. This is regarding any Fourth Amendment concerns regarding landlord-tenant issues. And this bill, again, the concern that I think a lot of voters have is when you're a tenant and you don't own the home, when you were voting for issue 2, you were under the impression that this would allow you to use adult cannabis. So the concern is, what is the concern regarding landlords adding additional provisions to their lease to require to, I guess, add additional regulations to check on the unit, to require additional visits? Would those possibly bring up any Fourth Amendment search and seizures possibly?
I'm not sure about the Fourth Amendment issue, but certainly it would, possibly allow a landlord to use a pretext of a person vaping cannabis when they want to get rid of the renter anyways, for some other reason. And they also could just get rid of them for doing something that was legalized for adults and that doesn't have any negative consequence on their neighbors or the landlord.
And are there any other states as far as landlord-tenant issues? Or are there any other states that go to this extent as far as limitations?
I believe none have I'm sorry.
Yeah.
I believe none have a criminal penalty as is included in this bill, which is outrageous. And I don't think you have it for other things that the landlord might not approve of somebody doing and might not include in the lease. I don't know of any that prohibit vaping, but I can't say for certain that others don't. But our model legislation prohibits smoking, and most of the state laws or allows a landlord to prohibit smoking in a lease as they can do with cigarettes.
Representative Sonnenberg with a question.
Yes, thank you, Chairman, and thanks for your testimony. A little bit not germane to this conversation, but taking advantage of your experience and knowledge, noting that your group is in DC, and I assume you follow this on a national basis. I mean, the federal government has a responsibility here too, in terms of the 2018 Farm Bill with the hemp, and that marijuana is still not totally legal federally. Are there things? What is the federal government's responsibility here, do you think?
I think the federal government should listen to 70% of voters and make cannabis legal at the federal level. But clearly it has not done that, despite there being overwhelming support. And even the president is now supportive of legalization. But that said, every state law, should bear in mind the fact that this is all still federally illegal. And for example, when you have all of this recriminalization that's happening, you'll have new people getting criminal convictions that wouldn't otherwise, that could also have consequences at the federal level. For example, if somebody's a legal resident but not a US citizen, if you have admitted to using cannabis twice or more, or if you have 2 or more convictions, you can be deemed permanently inadmissible. So this could have devastating impacts for people that have built their families and lives here and even served in the military.
Thank you very much.
Thank you. Representative Plummer with a question.
Thanks, Chair. I hear you guys talking about buying out of state and bringing it in the state and making it illegal. I didn't draft the bill, but I'm wondering if the intent was to help out Ohio business owners. You guys, like you guys grow it, we buy your product in Ohio. That may have been the intent. So are you seeing value to that statement?
I don't know what the intent is. If it is, I think it's misguided. I don't think people are going to buy it in Ohio because it's illegal for them to have bought it from somewhere else. I think they'll just try not to get caught or hope they don't get caught. Maybe they'll buy it in Ohio once and use a packaging from Ohio if they're smart and crafty. I've heard of that happening in Louisiana where they have medical cannabis has to be bought within the state. So if that was the intent, I think it's inappropriate to criminalize people to protect a business. I don't think that's the best approach to help businesses. I don't think it would be successful, and I don't think it's in keeping with the will of voters.
Any other questions for the witness? Seeing none, thank you for your testimony.
Thank you.
Our next witness is Tim Johnson. Welcome, Mr. Johnson.
Good afternoon, Chairman. If I may, with all due respect to yourself, to the other committee members, to the people in the room, I'd like to bring up the fact of limiting our time to 3 minutes when the proponents were allowed 5 to 8 minutes. And this isn't the first time this has happened. You've cut our time short. Most of us came here with 5 minutes to testify under what we have in the past, and we get cut short. I just want that to be on record, to being unfair. With that, Chairman Thomas, Vice Chairman Matthews, Ranking Member Isaacson, and members of the House Judiciary Committee, thank you for the opponent testimony or opportunity to present Opponent testimony before you today regarding House Bill 160, an anti-cannabis bill that would place Ohio back into a new era of cannabis prohibition, creating laws criminalizing the cannabis community and endangering the existence of Ohio's current cannabis industry programs. A bill that would dismiss the will of the people. My name is Tim Johnson. I'm a retired law enforcement officer and an Air Force veteran and the president and founder of Cannabis Safety First. I've spent the last 10 years here at the State House, the People's House, as an advocate, legislative advisor, security and safety specialist, and a subject matter specialist as a participant in creating the Ohio Medical Program, the hemp program, and as a policy advisor on issue 2. House Bill 60 presents as a redundant bill. Most of what's in there is already included in the medical program. We're rushing House Bill 160 through by shutting down the DCC, who were promulgating the rules, carrying over from the medical into the adult program. And now we have 160 coming in to criminalize and to minimize what's going on in the state. It's very obvious that some of the handful of the major license holders in Ohio are behind us also, when you look up their contributions. The paramount reason for legalization is to correct criminalization of laws, free up our courts and first responders, and to address decriminalization of cannabis. House Bill 160 presents as though the Ohio Revised Code 2925 chapter, drug laws, might as well be written to further criminalize the cannabis community. As I think I've said, legalization is not legalization until consumers and patients are free from prosecution. I've heard it over and over about the safety of the children in our state, how false that can be. Shame on you. If that's the truth, the program you submitted earlier was great. Why aren't we addressing the 47,000 deaths from firearms? Why aren't we addressing the 2,700 permits for alcohol, the #1 drug killer in the world? Why don't we address tobacco laws? 8 million deaths yearly. Melatonin, killing children and adolescents, 11,000 visits to ERs in the past few years. Caffeine, an Ohio case, powdered caffeine, you can buy it right into the gas stations with the complaints for the Delta 8s and THCAs on the hemp. House Bill 160 will do nothing more than promote the consumers and patients in Ohio to go to other states, to buy online, to buy from the illicit market, to home grow, unregulated, untested. As a result of this, it'll kill the program that we have trying to protect us. Issue 2 is an epic failure, in my opinion, and I'll stand by that strong. It provided no criminal justice reform. It protected license holders and it provided guidelines for the regulatory bodies. It was also discriminatory and not being inclusive and taking the 14 standalone processors and making them a vertical integrated program. It was an obvious monopolistic attempt to get rid of them. A few things I'll touch on here that you were talking about on, well, let's just say we're attracted to economic impact opportunity, otherwise known as social equity, which was in 2018 by PharmaCann lawsuit ruled unconstitutional here in the state of Ohio. So can we get past social equity and use another phrase and allow those 50 dispensaries and 40 cultivators to be issued? The impact of the business impact could cause the loss of 300 plus new companies in Ohio. You can see the rest of my testimony here. I've added 4 acts, hopefully to be bills over the last 4 to 5 years since I've been here, addressing all these issues that have fell upon 3 different General Assembly's ears, addressing the revisions of what should be done in Ohio with the programs, the hemp program, the cannabis program, probable cause. I'll bring probable cause up real quick because it's been mentioned twice. The prosecutor and Rep. Williams, if we're going to say that the smell of hemp and cannabis smell the same, therefore you can't smoke hemp. We can't determine the same. In my opinion, that would carry over to a traffic stop. The officer nor the K9 narco dog can determine whether it is hemp or cannabis. So does that constitute an illegal search in a car, on a person, or in a building? These are some of the things we might want to take into consideration. You can see some of the other stuff I've added there. I've added a list of resources that you can go through as far as my
Sir-
program.
Sir, thank you for your testimony.
Yeah, thank you for your time, sir.
has
And
expired. Are there any
respect
questions
if
for the
there's any
witness?
questions, I am willing to answer.
Representative Tim, with the question.
So I'm reading your testimony, and I want to turn to the point, sorry, didn't share things, on the illicit market. When we look at alcohol, right, you go to a bar, you go to Kroger, you can choose from a number of brands. Maybe some local craft breweries have their cans and their brands in the store as well. When we look at marijuana and hemp, and really it's just a lot of outside large companies gobbling up the process vertically, top to bottom. Is it in your opinion that if we are not allowing for more small businesses and people to take advantage of the legalization of marijuana, production of marijuana, growing, and production of products, that it will lead to an increase in return to the illicit market? I'm just thinking back through like prohibition. We don't have as many like bootleg joints and people like drinking moonshine as we do because there are corner stores everywhere people can get a bottle. So how does this sort of turn to the illicit market, and how do we prevent the overcriminalization of people going to the black market to get marijuana? And I ask that because I'm concerned about children getting things from their friends, or marijuana laced with other illicit drugs, etc.
Through the chair to the Representative Timms, thank you very much. It very much will promote by limiting the participation in the program as far as for license holders. It will eliminate the rights, the criminal protection rights, the criminal justice reform for consumers and patients. If you're going to criminalize us, we might as well be criminals and stay in the illicit market. It seemed to be safer there, especially with these outrageous laws that are language that they've been introducing now to criminalize us. Yeah, I would definitely say that going to, you can go to the corner grocery store and you can buy what you want as far as alcohol. You can buy an unlimited amount. There's no limits to that. With cannabis, we have limitations. I do have one concern with, as far as on the limitations, if I'm only allowed to have 2.5 ounces of possession while I'm out and about in the community, why am I allowed to buy 9 ounces of flour as a medical patient? Why am I allowed to buy 2.5 ounces at 10 different dispensaries in one day, have 25 ounces? I purchased all of that legally, but on my way home, I get stopped. I'm over 2.5 ounces. Those laws conflict with each other, the statutes, what they say. So yeah, I would agree that definitely a return to the illicit market. It will make it stronger. The illicit market is something you'll never get rid of. Though there are those in Ohio that have a fantasy of getting rid of it. We still get Gucci purses and Nike tennis shoes and so forth off the illicit market. So, and as far as moonshine as well. So long live the illicit market is what I say.
Representative Sonnenberg with question.
Thank you, Chairman, and thank you, Mr. Johnson, for coming in and for your testimony. I wanted to thank you for bringing up these other activities that we don't currently regulate as well as arguably we should and could here, like the firearms, deaths, alcohol, et cetera. Do you have any, I know you're not a doctor or scientist, but can you speak at all just from your background on the long-term use of chronic alcohol use, how that's worse for an individual than using cannabis?
Yes, definitely I can. Through the chair, the representative. As an officer on the street for 20 years, I'm sad to see Representative Plummer leave. Got an answer for his question, but I think law enforcement as a whole is going to tell you that cannabis wasn't a problem on the street. That wasn't the drug that we were saving lives for. It wasn't the drug causing domestic disputes. It wasn't the drug causing accidents on the roadways. There were far more alcohol and pharmaceutical drugs and other items, the cell phones and so forth, causing the accidents. So from my personal experience and from my data and so forth I've collected over the years, those were the areas that we had problems and concerns with. So we didn't see so much as traffic roadside stop when we pull up to the car. 6 out of 10 cars smell like cannabis odor, and those people didn't want to fight. They didn't want to run. But you pull up at somebody on alcohol or some pharmaceuticals, Might as well call for backup because the fight was on or the car chase was on. Yeah, that's what we've seen. The same thing, just, outside of traffic stops, the same thing going to domestics, et cetera.
Okay. Yes, no follow-up. Thank you. Thank you.
Any other questions for the witness? Seeing none, thank you for your testimony.
Thank you, sir.
Our next witness is Gerald Moore. Welcome, Mr. Moore.
Thank you for having me. Good morning, everybody, representatives. I want to thank everybody for showing up, especially for the people that follow me on Ohio Cannabis Report. My name is Gerald Moore Jr. I'm the president of Green Environmental Outreach, a 501c3 nonprofit. I'm also the founder of an independent media channel called Ohio Cannabis Report, former All-American at Ohio University, captain and NFL free agent. As a husband, father, nonprofit leader, the last few years have been very difficult for me. Me and my family experienced a stillbirth, which has been brought up here by my wife in another committee. And so, again, when we talk about cannabis and legalization, this is something that's very near and dear to my heart. So I'm also a proud graduate of Ohio University, the first university in our state founded while the Ohio Black Codes were still law. This bill feels like we're headed back to that direction. As the founder of Ohio Cannabis Report, an independent media outlet with over 2,000 followers, I speak daily with patients, legacy growers, small business owners, and workers in working Ohioans. What they need is access, fairness, and opportunity, not corporate control and criminalization. I strongly oppose HB 160, even though I know it's not perfect. The caps to dispensary kills craft grows, locks out small entrepreneurs and legacy operators. It guts the social equity, which I know we've talked about, but there is a workaround. I come from one of those communities that have been disproportionately impacted by the war on drugs. I'm a product of at-risk youth. Both of my parents were teenagers when I was born. So I've been born into the war on drugs, the crack epidemic, poverty, and all those other things, and I've been able to make it. And so when you look at this bill criminalizes before it heals, and it punishes renters and patients who rely on home grow and legal consumption options. Obviously, there's not a lot of places to go if you don't have a home to consume, which is a huge issue with our community. It also lets employers fire workers for THC in their system, even when they're not impaired. As a Christian, I don't support the views of the virtue-based groups backed by this bill. My faith calls me to a healing and justice, not exclusion. I recently supported my wife through a stillbirth. We've both testified for both stillbirth awareness, and we know the value of care, support, and compassion. For us and many others, cannabis is a part of that healing process. HB 160 would reverse the will of the voters and put profits before people. I urge you to reject the bill and stand with the communities who need this industry to be inclusive and just. Thank you very much.
Thank you for your testimony. Are there any questions for the witness? Representative Calendar's question.
Thank you very much, Mr. Chair, and through the chair. You ended with urging rejection of the bill. Would you agree that there are some things that need to be done? I think you were here earlier when we talked about labeling and children and access, that there are some things that need to be done that are not inconsistent with issue 2, but for the industry, for the sector, and for the general public would be things that you could get behind and support?
Well, when you look at, I've been a medical patient ever since we started, through the chair, sorry. But I've been a medical patient ever since we started. I mean, I was a legacy user. As a football player, you deal with a lot of pain, right? We don't talk about football players often. Obviously, we're talking about the Cleveland Browns. But I would say 75% of professional athletes, collegiate athletes are medicinally using cannabis for some reason, right? Because we can get pills or whatever. When it comes to kids, the way that the program is set up, it's not targeting children. I've been a stay-at-home dad for the last 8 years. My children have never had access to my products. I talk to my children about the things that I'm dealing with. I'm 35. I deal with chronic pain every day. Arthritis in both ankles. I've had plenty of concussions through football. So again, I don't think children are being advertised to in this program. We have lock boxes. We have Ziploc baggies. The gummies aren't advertised towards kids. They don't look like kitty gummies. So I think obviously there's some things, but I think we use the children as a pawn, right? Like the children aren't the problem, it's us. You know, we need to find common ground and understand that we need to protect our children, right? We're not talking about childhood obesity, which we could help with. Again, guns and firearms. There's a lot of different issues when it comes to the children. Let's fund the children, and we can use the tax money to do that. Thank you all.
Chairman, I just want to let you know I received a message from him. I'm a part-time caregiver for Simon. He dislocated his hip this morning. Is not going to be making it out of bed. He suffers from severe pain. He uses my RSO medications, but won't be able to make it in today. But asks that you guys read his testimony.
Great. Thank you. Please note Mr. Dunkel's testimony on your iPads. Next witness is Kat Packer. Kat here. How about Mr. James Bybart? Welcome, sir. Please proceed when you're ready.
Chairman Thomas, Vice Chair Matthews, Ranking Member Isaacson. My name's Ted B. Barton. I'm an Ohio licensed attorney, also a member of the Ohio Cannabis Small Business Association. I've participated deeply with both caucuses in both houses in drafting House Bill 523 in 2016. I was then appointed by the Ohio Speaker of the House as the original patient advocate to the Medical Marijuana Advisory Committee. My wife is also a social equity licensee, standalone processor in the state of Maryland. This program is incredibly important to me, and I appreciate everybody's effort here. So the basis of my testimony today is to ensure that we have a pro-Ohio regulated business environment. This is not about expanding the use of cannabis in our great state. This is not about trying to engineer environments that have new cannabis transactions occurring. It's that the transactions that are already occurring would be happening in a regulated, tested, taxed, and quite frankly, normalized environment. I think you've heard wonderful testimony from the advocates who've been fighting for years for good cannabis policy. The underlying theme is this is actually about good government. The cannabis backdrop is just us having conversations as the electorate and the elected and saying, what is good policy in this state? And so it starts out by talking about the supremacy of the illicit market and the cross-border transactions that are happening in Michigan. It also involves talking about the fallacy of THC potency caps, remedial vertical integration, restrictions on commercial speech, and the sheltering of the medical cannabis industry such that it does not become cannibalized by the adult use industry. So in 2021, it was estimated that there was $100 million worth, or $100 billion worth of illicit cannabis sales in the United States. And so Ohio has long been estimated at a $2 billion illicit market. So these figures suggest that the historic cannabis sales in this state, as we've heard from Tim, are not likely to be totally eradicated. But what we can ensure is that those who are consuming cannabis products do so as safely as possible. So Ohio residents spent an estimated $700 million in 2023 in the state of Michigan. And for instance, the largest month of sales of Michigan cannabis were actually in August 2024, the first month we had regulated adult use sales in the state of Ohio. The point is that the cannabis transactions are occurring. And if we do not create regulatory environments that then do not support the safe tested use, then all we're doing is ensuring that Ohio is less safe, not more safe. Part of that is the THC potency caps.
We, in Ohio, have an existing regulatory framework that already limits dosage per unit. So providing an appropriate science-based method for safeguarding consumers already exists in this state. The potency caps risk incentivizing both the illicit market and out-of-state markets such as Michigan, which don't impose such limitations, to remain attractive alternatives for the consumers. Again, the basis is about purity. So when you are reducing THC potency, all you're asking is that the medicine be adulterated to get under an artificial limit rather than appropriately regulated for its dosing. And that also reminds us all that there is no scientific risk of fatal cannabis overdoses. So at the end of the day, if I put a never-ending plate of cannabis brownies in front of you, you'd first overdose from the salt and the sugar before you overdose on cannabis. Number 3, issue 2 awarded an increased market advantage to all the operators, except, as Tim mentioned earlier, the standalone processors. And the reason why that is so important is going back to the House Bill 523, we've sought to create a program that encourages consuming cannabis in forms other than smoking. And so the processors in particular are incredibly important to this ecosystem. And respectfully, HB 160 has just not done enough to foster a healthy regulated industry. And as we continue to look at, many of the statements that I'm have up here are going to not earn me a lot of friends, whether it's with the traditional community that I fought so closely with. But one of the real issues that we've had as it relates to cannabis legislation, going back to its prohibition in the first place, is having a Schedule I drug where effectively we're telling our kids cannabis is as dangerous as heroin, ultimately ends up saying, what else are they lying to us about? And one of those considerations that we're going to continue to get back to over and over again is what's leading people to Michigan isn't the beautiful lakes and countryside up there. It's that not only is the product cheaper, but even if it were not, we have better quality medicine in the state of Michigan because of the market dynamics and the competition that it has allowed. So coming from a family who, again, my wife comes from a community that has been historically disproportionately impacted by the war on drugs. Being a licensee that was awarded one of those licenses under a social equity program, it doesn't matter. Those licenses will end up being an opportunity to ruin the financial future of your family if there is not a free market principle to the production of this medicine. That's what so many of the advocates are fighting for. Now, admittedly, to my friends in the hemp industry, I'd say, just like we don't want to say a Schedule I drug is that cannabis is as dangerous as heroin, we also don't want to say that THCA is a flower is something different than it is not. Until we're having honest conversations with the regulators, they're not going to understand these issues, and full market participation is not going to happen. We need to continue to have honest conversations and seek to have good regulatory solutions.
Sir, thank you for your testimony.
Yeah.
Are there any questions for the witness? Representative Tim, question.
Thank you, Chair. To the witness, I wanted to talk about what you mentioned about free market and the single processors or standalone processors. Is it, in your opinion, that is going to drive down competition in Ohio if our standalone processors aren't allowed to compete, not just with Michigan, but with other processors who are allowed to grow and sell products as well?
That's an excellent question through the chair. That is not only the case theoretically. We're seeing these businesses, and I'm sure you will hear more testimony before this committee before it's all over. There are some wonderful homegrown businesses here in Ohio that are going to go out of business. The standalone processors, of which there are roughly 14, represent the last of the Mohicans. They were individuals who did not sell out to larger corporate interests and are largely Ohio businesses that are either minority-owned, woman-owned, or in jurisdictions that are in desperate need of jobs. So when you're talking about a standalone processor, you can't make ethanol without corn. So if you can't get access to biomass, then you are ultimately going to not be able to produce those products. One of the things that we're seeing with the kind of products that Representative Callender was so brave to pull out of his pocket today is that these are all products that are promoting THC, okay? The reason why THC becomes so prevalent as a cannabinoid is because it can most easily be extracted from bad material that has ended up being compromised by mold. One of the issues that we have in this state is we have a tremendous mold and yeast issue in our program. The DCC has been putting out multiple statements on this. The large-scale cultivators, the reason why it's so prevalent there is not because they're bad people who don't care about producing good, clean medicine. It's because these large grows are so difficult to eradicate that kind of infestation. So what ends up happening is if you eliminate these small grows, what you've done is eliminate the craft principle that would be contributing to a higher quality product ecosystem. And at the end of the day, that is something that ultimately hurts patients. And when we continue to push this environment all towards an adult use, we end up cannibalizing the cannabis industry, which again, does not have a parallel in that way with either tobacco or alcohol. And so, yeah, please. Yeah.
Sorry, I know we're running short on time. I just wanted to follow up on what you said about the potency caps. I hear you about that and you know the brownies. However, when we look at alcohol, what the federal government has done, which they have caps on and they tie that to taxation.
Absolutely.
Is there a potency cap that you would support?
Yeah.
For legislation coming out?
Yeah, and I appreciate that question. It comes back to the underlying thesis, right? Which is we already have dosing limitations. So with cannabis, when you extract cannabis, the purpose of that property is to try to mimic the exact compounds that are found in the original starting material in the plant. It's why the standalone processors not having access to biomass is such a limiting issue for quality. So the point is that when you're extracting from that, it's whatever is present there in the plant. Then we have the ability to control the dosage of that and whatever the idea is a milligram in a pill. We already do that. So if you're at a place where you're trying to artificially lower that potency, what that means is you're introducing something foreign to that medicine. And we saw what happened there was it was vitamin E acetate was being used to exactly do this. And it was something that was causing people to get sick rather than not artificially seeking to limit that THC potency and doing what we worked so hard on in the Medical Marijuana Advisory Committee back in 2017, work I'm very proud of, to innovate for the first time in cannabis dosing restrictions. And it's worked very, very well here in this state.
Any other questions for the witness? Seeing none, thank you.
Thank you.
Our next witness is Blaze Catter. Welcome.
Thank you, Chairman. And I certainly don't envy the work that this committee has on this bill. It's certainly a monumentous task. On behalf of the Ohio Association of Criminal Defense Lawyers, I just wanted to bring forward some concerns we have on some very narrow technical issues regarding the criminal penalties and, more importantly, providing very clear lines for prosecutors, judges, and defense attorneys alike as to what is permissive and what is not. Generally speaking, the two categories we have that I most wanted to talk about was marijuana in the vehicles and sort of its relation to OVI, as well as the potential home grow and limitations as you're considering and weighing those considerations. First, as to the vehicle, I certainly think that there is it's understanding why it would be, the General Assembly may consider criminalizing the possession of marijuana in a vehicle unless it's being transported from a dispensary. So I'm not addressing the wisdom of the underlying bill. The question is, what is the penalty and what is the prohibition should be? And right now, the bill as proposed is mirroring OVI penalties, yet the behavior is simply a passenger or even a backseat passenger parked on private property in a non-moving vehicle. And yet that would be giving a mandatory 3 days in jail such draconian penalties do not even face for, assaults, domestic violences, and other very serious misdemeanors. And so I think the suggestion I would make is that the open container statute is a very good mirror for this, where it talks about, one, prohibiting the possession of the substance in a vehicle that is either on a roadway or in an area open to vehicular traffic, which would cover parking lots or really anywhere you're out and about in the public. So that language already exists and is, I think, a very good base to build off of. I think that with marijuana, it's very difficult to necessarily distinguish, if it's being smoked or passed around. It is it's a shared substance, much more even than alcohol. And so I could see a situation where if there's marijuana being used in a vehicle, the occupants of the vehicle would be cited. I think the minor misdemeanor threshold is the appropriate, the same as alcohol. It's a citation, and it gives law enforcement a valid ability to just cut that behavior out while appropriately balancing, I think, its seriousness. Obviously, if the person is moving the vehicle, operating under Ohio laws, having caused movement of the vehicle, and they're under the influence of marijuana, OVI laws apply in full force to that. And so I would just suggest that currently the bill says that a driver would be, quote, subject to 451119, actually might diminish the protections rather than enhance it, because it's already very clear that the OVI applies, and saying subject to might almost expand or be unclear about a person who's sitting in the operator's seat but not causing movement of the vehicle. I think that the lack of clarity in that cross-reference is a little troubling to us, because it would open up some difficult interpretational questions for judges and defense attorneys. So in parallel to alcohol, we do have an offense called being in physical control of a vehicle, where a person who's in the driver's seat who is under the influence but not causing movement of the vehicle is still subject to a first-degree misdemeanor, but it's not an OVI in the sense of the mandatory minimums. So I would also be supportive to say that a person who is actively under the influence of marijuana, just being in the driver's seat, could be an enhanced penalty, even a serious misdemeanor, to mirror the physical control statute. And perhaps it would just be easier to amend the physical control statute to make it clear that the marijuana applies, or create a cross-reference. But that's another solid foundation to clear some really maybe inartful language that could provide some clarity. Finally, the other final concern is the possession of the harvesting of a home grow operation. So bill is very clear that whatever the limits and whatever the thresholds that are established end up being, it is legal to grow those plants. So at that point, there's an exemption from the criminal law for the cultivation, so long as it's in accordance with the standards prescribed by law. But at the moment it's harvested, then there's no similar provision. So it would seemingly revert back to the personal possession limits. And that is, I think, very obviously far lower than what the yield would be, at least under current law and even in the proposal. And so, again, I don't necessarily implore this committee to take any specific threshold or any specific amount, but I think from a point of fundamental fairness and respect, that if you're allowed to grow it, then you should be allowed to possess the yield of that. And so the law would have to, I think, have at least a harmonization between what the yield is from the legal amount of plants versus once it's converted into a dry weight. And that is a little difficult. So I think that could maybe use some brainstorming and some power to how to necessarily achieve that. I would suggest perhaps that it have to be put into a very specific container and sealed and then noted as a homegrown. But enforcement of that is certainly a tricky thing. But for just promoting respect, rule of law, and clarity, there has to be, we respectfully suggest, equality between what you're permitted to grow and then possess the yield of that. So with those two issues, I would express any helpfulness that we could do to help, tidy that language up and provide some consistency and clarity.
Thank you, Chair, and thank you so much for the testimony. Very compelling. Do you also have a position on some of the other elements that could and should be aligned to how we treat alcohol and how we criminalize or just regulate alcohol, in terms of over possession, first public offense for public use violations, right? The criminalization of sharing non-commercial amounts of cannabis, right? Passing a joint, right? Does the association have positions on just making it so that we are mirroring cannabis law to alcohol law, which is clearly what the voters voted on?
Yes, thank you. To the chair, to the ranking member, I certainly think that from a public use and a sort of, controlling the streets, such a parallel to disorderly conduct. So first, being out and being under the influence of any drug or substance is disorderly conduct, and is actually the arrestable version of that, so that the officers can remove the person from the scene and actually possess. So I think that being impaired in public should be probably under the umbrella of disorderly conduct. I think that public use, absent any additional escalating behavior, should be a citation, similar as alcohol. That I think open container more broadly. I think the voters in this history of Ohio is that intoxicating substances in general shouldn't be used just out in parks or out in things. So I would certainly support that to just be broadened under the same, for the most part, disorderly conduct statutes, or citation for having an open container in public, which is the same open containers within a vehicle. So that minor misdemeanor, I think, is highly appropriate. As for the communal sharing aspect, I would not make the incidental. So basically, sharing in the consumption for me is a distinguishment from sharing in the raw product. We have no position on the sharing of the actual raw flower or any THC related product. I certainly don't think that I wouldn't advocate for any strong criminalization of that. But the incidental sharing as sort of communal consumption, I think, should just be beyond the reach of the law. That's not something, people share drinks, people, so long as they're of legal age and legally available to consume that, then that would be something that I don't think ought to be criminalized. But otherwise, I think that there is room for just about any law that applies to alcohol to be amended to also apply to marijuana, with no real distinction or meaningful difference. I appreciate it. Thank you.
Welcome.
Thank you. Appreciate you having me. So to the House Judiciary Committee, I want to thank Chair Thomas, Vice Chair Matthews, Ranking Member Isaacson, and the members of the committee to allow me to speak before you today. My name is Matt Hyde, and I am in opposition of House Bill 160. As a voter, back on November 7th, back in 2023, I, like myself, along with 2,226,398 other people, Ohioans of voting age, supported its passage. In doing so, they decided to regulate adult use cannabis for people over 21, and among other things there. But just skip through a few things just so I can make sure I get to them here. First thing I do want to remind all of you that looking at the data, every one of your districts, every one of your counties that you live in, you all passed issue 2. Every single one of you, except for Stewart. So no wonder why he's the one who actually created who sponsors it. In terms of, everybody seems to know what the core was until they didn't know what the core was. So I'm going to explain what I feel the core was, and probably lots of other people explain what the core was. Number one, of course, the legal sale of adult use cannabis to adults 21 and over. The ability for Ohioans to grow 12 plants at home. The establishment of the Social Equity and Jobs Program. 40 level 3 cultivator licenses for social equity and jobs applicants. That's 5,000 square feet. We understand that there was going to be a THC cap of 35%, but 90% on concentrates. Again, bringing in other things into the product. Standalone dispensaries to get 1 additional dispensary license. May I have my pause? Okay. Standalone dispensaries get an additional dispensary license. Okay. So social equity, 40 level 3 level cultivators, the THC cap. We understood that standalone dispensaries got an additional dispensary license. We understand that level 1 cultivation received 3 dispensaries and 100,000 square feet of grow space. Level 2 cultivation got 1 dispensary and 15,000 square feet of grow space. Tax revenue was to be distributed 36, 36, 25, and 3 as to social equity, host communities, mental health and addiction services, which I can't believe you guys are now putting that in there, and just the operating costs of the DCC. And lastly, the processors got nothing, nothing. So in stark contrast, House bill undermines the will of the voters by inserting mandatory minimum sentences for cannabis offenses. Under this bill, a person committing such an offense is going to be at minimum jail of 3 days, up to 6 months, at least $375, the potentially suspension of their license or permit for up to a year. So this obviously does not align with what we expressed in issue 2. The reality is that it gives us as cannabis users having mandatory minimum sentences is just ridiculous. It puts, so I looked up what other mandatory minimum sentences there are in Ohio. And those offenses would be certain felony drug and sex offenses, aggravated murder, felony OVI, or assaults on peace officers. Mandatory minimum sentences that you are now putting cannabis users in the same area with. So why do we have this drastic change? I wish Mr. Stewart was here. So how can we justify mandatory minimum sentences for cannabis while lesser sentences apply to crimes such as possessing an open container of alcohol in a vehicle, which is considered a minor misdemeanor, like said earlier, and it is up to a $150 fine. So answer those questions earlier. So as a consumer myself, I don't have a lobbyist speaking for me. So that's why we have elections, and that's why we have you all here in front of us. Speak the word of constituents, 57 to 43. Some might consider that a landslide. 15% is generally the area that's expected, but it was 14%. So landslide area, right? It's crazy for me as well that those who are creating these sponsors and bills like Huffman and Mr. Stewart here opposed issue 2, and yet you're writing the bill. It makes no complete sense. Because of that, we don't feel we have representation. We've created the Cannabis Consumer Coalition. So I know that a few of us have already mentioned it. We are just a group of people who are unhappy with how the medical program is and how this bill is. And we want you to come to us, your constituents. We're all around Ohio. Just talk to us. Find out what we want, what we think is reasonable, and we want to work with you, especially Mr. Williams. So let's see here. And one more thing, I really think, unfortunately, cannabis still has this amazing stigma on it. And so I believe people are scared because of these employer protections. They don't want to come forward because of these employer protections. I would actually like to see some employee protections placed in here. So people who use cannabis at home, not while at work, use it like alcohol, right? Just educate. We just need to educate these people, educate yourself. Your minor cannabinoid system, your endocannabinoid system is there for you to balance your body. So any questions at all? I am open.
Great. Thank you for your testimony.
Remaining.
Any questions for the witness? Seeing none, we thank you for your testimony.
Thank you.
Next witness is Ashley Mosby. Got it. All right, Michael Smith here. Welcome.
Thank you. So I want to thank the chair, the vice chair, ranking member Isaacson, and members of the House Judiciary Committee for allowing me to testify today. I have a pretty long written testimony. I'm going to skip a lot of it and kind of go to some main points here that I really want to talk about. I'm not affiliated to anyone in the cannabis industry. I am just a normal guy who's Ohio voter that's kind of just pissed off that we're even in this room having this conversation. So I have an MBA from Defiance College, Master of Science in Cybersecurity from Franklin University, and I'm a technologist here in Columbus. Been in Ohio my whole life, and it seems like we're constantly coming in here and voting and having to then refight for what we just voted for. And it's getting a little old. Ohio voters overwhelmingly passed issue 2, and HB 160 is an attempt to override our democratic process. HB 160 is not improving cannabis policy. It's designed to limit competition and reinforce corporate greed and market manipulation. So I want to talk about the home cultivation problems that we have and then jump into the recriminalization. Home cultivation. I have a son with Crohn's disease. He was just down visiting. He lives in Northwest Ohio. A couple of days ago, he came in. I gave him an ounce of weed. I gave him a tincture, and I think he took some gummies too that I made. And I go up and visit him, same thing. What terpenes do you want? I take those to him. I am also a medical patient, but you're trying to criminalize me giving my son medicine. That's what we're talking about here, as soon as we transfer cannabis. The other thing with that is it's not really enforceable, but it's exploitable, meaning unless you knew what I had in my house and what my son had before he came in and then checked him when he came out, which you couldn't do because there's no probable cause, you have no way to know that I transferred home grow to him. What this is going to do is allow overreach to where we're going to be able to now harass and target minorities and are also other populations that have been negatively impacted by cannabis by having these laws in there. Because you can see a guy that hands someone else a bag of weed and he says, hey, buddy, roll up a joint. That's a crime. He just transferred cannabis. It's ridiculous. So home cultivation, fundamental right and lifeline for medical patients, and you're messing with that. I actually also think that plant count should be increased and not decreased. I think we should actually probably move to a square footage measurement because plant count does not equate to yield. Simply, it doesn't. There's plenty of growing methods. Also, public service announcement, stop equating plants to joints. As soon as anyone says that, you lose all credibility. It just doesn't make rational sense. It's not even how it works. All right, recriminalization. So public consumption. I was just in Dublin, in a Dora area, drinking alcohol. Not a problem. I'm in the public. Dora drinking outside is really awesome. Like, we're allowed to do that. But you want to criminalize cannabis usage? We talk about the smell. I have to walk through cigarette and cigar smell all the time. The problem with cannabis smell is it's stigmatized in your brain to say, this is bad. Because 40 years ago, Nancy Reagan said cannabis is bad. And all of us think it's bad. Like, that's where your brain goes to. That's not the case. And also, cannabis lounges, which I know was brought up earlier. I was just in the Virgin Islands. They had them down there. Oh, it was great. It's a nice experience. We can't have that here. There's no way we could because you can't transfer material. However, there's alcohol lounges. If you Google bar from this building, your phone will get measles instantly. So, I mean, it's just all over. So, and then finally, economic impact of this. So this, if I wanted to do an economics class on how to kill an industry, I would pull out the Ohio playbook and do it. Very simply, you have an oligopoly in the state. You're trying to strengthen even more. That is a job killer. And if you look at, well, 60% of people voted for cannabis, 40 didn't, 100% will turn out for a job killer like this. So it was estimated to create up to 50,000 new jobs. You won't let anybody into the market, though. We talk about the illicit market. How do we stop it? It goes back to bootleggers. We talk about that in prohibition. If you let them into the market, you're going to reduce those numbers. But all you're doing now is letting the voters subsidize people who grow poor cannabis, actually. So you got mediocre products who are being subsidized by the voters because you're not letting anybody else in, and wonder why the illicit market grows. So instead of protecting public health and market fairness, you are suppressing consumer choice and punishing medical patients. Any questions? All right.
Next one is Daniel.
All right, you guys, thank you, General Senate Committee, for having me today.
My name is Daniel Delsinger Jr. I'm a proud Ohioan, a medical cannabis patient, and a success story. I'm here to speak in strong opposition to House Bill 160, House Bill 198, Senate Bill 56, and any legislation aimed at undermining the will of 57% of voters who supported Issue 2 in November of 2023. Cannabis has saved my life. I'm a former alcoholic and benzodiazepine addict who spent weeks at a time unconscious, losing precious time with family, loved ones, and at school at Ohio University. In 2017, I turned to cannabis as a recovery tool, and by 2019, I was a registered medical patient. Since then, I've been able to graduate from Ohio University, hold down 2 full-time corporate jobs, and an extra part-time job in addition to that. And furthermore, cannabis has helped me manage my anxiety, PTSD, ADHD, depression, and panic attacks without the dangerous side effects of the medications I once relied on. Since using medical cannabis, I've again held down 2 full-time jobs and experienced the best quality of life that I've had since childhood. Cannabis didn't just help me recover, it gave me my life back. I voted for Issue 2 because I believe in safe, affordable access and the right to grow my own medicine. Right now, capping potency, limiting dispensary numbers, and criminalizing adult sharing contradict both the spirit and the letter of what Ohioans voted for. We do not treat alcohol or tobacco users this way, substances with far greater harm potential. Cannabis is medicine. Peer-reviewed studies confirm its effectiveness in treating numerous conditions and reducing dependence on opioids and other dangerous substances. And I'm not sure if anybody realizes this or not, but we are in the middle of an opioid epidemic in Ohio and a fentanyl epidemic nationwide. And notably, there has never been a recorded cannabis overdose in DEA history. It is deeply frustrating to see the elected officials attempt to override the will of the people. Issue 2 passed in the majority of counties, including many represented by lawmakers now trying to gut it. This is a democracy, and representatives are elected to carry out the will of the people, not to impose personal beliefs upon them. Please do not turn back the clock. Let cannabis remain a tool for healing, for harm reduction, and for freedom. I urge you to honor the 57% who voted yes and oppose any legislation that seeks to dismantle what we have rightfully achieved.
Thanks for your testimony.
Thank you.
Are there any questions for the witness? Representative Sandberg with a question.
Yes, thank you, Chairman Thomas. Mr. Del Signore, just wanted to thank you for sharing your personal story and being brave enough to come in here and share that publicly. And I'm glad that your story is one that has turned out well for you.
Thank you.
Could you address what it is about cannabis that is able to get you, to wean off of these other more addictive and more damaging substances that you used to rely on?
100% Representative Sandberg, from myself to the chairman to the rep. So cannabis has served as harm reduction for me. It has helped me substitute those more harmful substances that I was using that were killing me for something that does not kill people. It has helped me, real intrinsically think about what I was using in the past to help me, and that was prescribed to help me, and further move forward with, cognitive ways to deal with my stress and anxiety without relying on those medications, those addictive medications, and by using cannabis to, further improve my life by, using it before I work out as motivation, or, things like that. Instead of drinking all the time or using Xanax to quell my anxiety, I can now finally think, I can now finally function, and I can now finally have the quality of life that I was seeking to have on the medications that were once prescribed to me. So it's harm reduction.
Thank you very much. Thank you, Chair.
Thank you.
Any other questions for the witness? Seeing none, thank you for your testimony.
Thank you so much as well, you guys. I appreciate it.
Our next witness is James Powers. Welcome.
Thank you. Chairman, Vice Chair, Ranking Member, members of the committee, thank you for the opportunity to speak today. My name is James Powers. I'm an Army veteran, medically retired, a father, an advocate, and Ohio voter. I've submitted detailed written testimony, but I want to offer a few key points in person. Let's be clear. HB 160 is not a fix. It's a full-scale repeal and replacement of what Ohio voters approved. And what replaces it? A more punitive, more corporate, less fair system that criminalizes home grow, repeals social equity programs, and redirects tax dollars away from the communities voters wanting it to serve them. This bill reclassifies federally legal hemp as marijuana. It caps THC with no scientific foundation. It bundles criminal law, employment law, zoning, and taxation into one bloated bill, raising serious constitutional concerns under Ohio's single subject rule. But beyond the legal mechanisms, this bill is full of contradictions. If this were truly about public safety, we'd be sitting in a hearing on alcohol or firearms. But we're not. Why not? We hear cannabis branding targeting children. But look around, Welch's sells fruit snacks for kids and hard seltzer to adults. On my way in here last night, 2 blocks away from the State House, Minute Maid Orange Juice, who also Minute Maid uses that branding on all kinds of kids' products, is advertising a hard seltzer 2 blocks here from the State House. Worth noting. No hearings, but cannabis, suddenly it's a crisis. That's not safety, that's stigma. That's double standard people like me have been living under for years. Let me give you a real world example. In August, Fox 8 reported on an Ohio man whose home was raided over cannabis. No charges, but the fear and humiliation, real. That damage was done. Stories like this are why voters passed issue 2 in the first place. And now the same state system that's overcharging patients and lost 6,000 medical users in 1 month wants to run adult use? Metric, the state's tracking vendor, is under federal scrutiny in a whistleblower lawsuit for allegedly failing to catch illegal diversion. Are we prepared to talk about that? I'm not here to argue cannabis is perfect. I'm here to say that HB 160 isn't the solution. I thank this committee for their time, and I welcome any and all of your questions.
Great, thank you. Any questions for the witness? Seeing none, thank you for your testimony. Our next witness is John Lynch.
Chairman Thomas, Vice Chair Matthews, Ranking Member Isaacson, and members of the committee. Good afternoon. My name is John Lynch. I'm here specifically to talk about the hemp portion of House Bill 160. For more than a decade, I've been making non-alcoholic beverages. I launched a national soda for Jenny's Splendid Ice Cream and create sodas for the First Lady's Imagination Library. I'm here to ask that you consider the language from Senate Bill 86 regarding intoxicating hemp beverages. This is what I make, just simple little canned beverage. These hemp products are federally legal and have been for 7 years now. They're available in retailers all across Ohio. As a manufacturer, I would much rather see my products governed by the 3-tiered alcohol system instead of a dispensary framework that can't even accept customer payments without jumping through hoops. The second point I'd like to emphasize is the economic benefit of treating hemp beverages like alcohol. Under this approach, these products are sold in grocery stores, restaurants, and other licensed venues, broad distribution that fosters job creation and spurs new businesses across Ohio, particularly in agricultural communities. Currently, I source all of my hemp from Kentucky. But hemp farming could be especially beneficial to smaller farms here in Ohio. Unlike hops for beer, whose local production has seen limited success, hemp has the potential to thrive in our state. An open retail environment is the only way to encourage this growth in Ohio's farming sector. My third point is just about consumer safety and transparency. An alcohol-style system for hemp beverages ensures labeling, production standards, and oversight. Just like beer, wine, or spirits, these beverages would clearly display THC content and safety guidelines, and they would be subject to age restrictions and responsible serving rules that retailers already use for alcohol. I was the very first beverage manufacturer to receive a hemp processor license from the Ohio Department of Agriculture back in 2020. My facilities are regularly inspected, ensuring all ingredients comply with federal and state regulations. I waited 4 years to begin making an intoxicating beverage specifically because of my concerns over the lack of age limits. However, alcohol distributors and retailers have embraced these products over the last 18 months, installing the same safety and compliance procedures they use with alcohol. Again, I'm just here to ask that you consider the language from Senate Bill 86 that treats these beverages different than other intoxicating hemp beverages. Thank you for the opportunity to testify, and I'm happy to answer any questions you may have.
Thank you for your testimony. Are there any questions for the witness? Representative Sandberg.
Yes, thank you, Chairman. Thank you for your testimony. So you're advocating for hemp beverages be sold both in bars and restaurants as well as in whether it's grocery store or liquor stores or
Through the chair, yes, I would like to advocate for that. This Senate Bill 86 currently does not include on-premise consumption, bars, restaurants. We are currently sold in bars and restaurants. We have been for, not my particular product is pretty new, but these types of products have been sold for 18 months now in bars and restaurants. I think if there was going to be a problem in bars and restaurants, we would have heard of some issues by now. You know, if we can't get it on premise, I'm happy with the way Senate Bill 86 treats it right now, where at least we do have a retail component.
Yes, please. Thank you. And are you okay with some limits to each serving or as far as content,
Through the
THC content?
chair, yes, definitely. I think there has to be a limit. Like, if we're going to treat this differently than all the different hemp products out there, I wasn't here earlier, but like the product that Representative Callender maybe had, it just makes sense to me to create a small limit. The limit that the Senate bill has right now is 5 milligrams per serving. All of mine are 2 or 2.5 milligrams. Through all the testing we've done over the last 6 months, like consumers like a very low dose beverage to where maybe they can enjoy 1 or 2 while they're at a bar, sitting next to somebody who's having 1 or 2 beers. So I definitely recommend a low dose limit for the beverages.
Follow up?
Yeah, please. Yes, thanks, Chairman. Are you familiar with the studies that more younger people are more comfortable with, let's say, drinking some of these THC infused products or using cannabis as opposed to alcohol? And what is your market studies and
Through the
experience?
chair, are you talking about people under 21 or?
No, I mean young adults over between 20. Let's say individuals between 20 and 40.
I've seen that number, but the interesting thing I think with these products is there really doesn't seem to be a target market. There's the 40-year-old female drinker who's using it in place of wine. These are available in rural bars, urban bars. Like, there really doesn't seem to be a limit to a specific market. There is, you know, a specific subset of younger people who seem to be wanting. I also make non-alcoholic soda. We sell a lot of non-alcoholic soda to bars and restaurants, and there does seem to be a trend of younger people doing things other than beer, wine, and liquor, and this would definitely fall into that.
Right. Okay. Thank you very much.
Any other questions for the witness? Seeing none, thank you for your time.
Thank you.
Our next witness is Charles Ellis. Not seeing Mr. Ellis. Eric White.
White, yes, sir.
Welcome.
Thank you. Good afternoon. My name is Eric Whited. I utilize cannabis in its many forms daily, medicinally, spiritually, and recreationally. Today, I was hoping to tell this to Stewart and Huffman, but neither of them are here today, but I've consumed over 300 milligrams of Delta-9. That helps counteract my anxiety, my depression, and the pain that I deal with every single day. Just want to let you guys know that we can still be well-spoken while we are under the influence. I am currently growing 12 plants at the home that I share with my father. At that home, I enjoy washing hash, pressing rosin, and making Rick Simpson oil. It's all legal per edit while written in ORC 3780. Today, I'm not here speaking on behalf of the level 1 license holder I work for. Neither am I speaking up on the number of concerned employees, the stakeholders, users, patients, or community members that I speak to on a daily basis. No, I'm being selfish. I'm speaking up for myself, and I'm angry today. Cannabis means a lot to me, personally and professionally. The potential ramifications of this legislation leave me baffled and frightened. Our state reps are claiming that people don't know what they voted for, but they don't know what's in their own bill. I find that offensive when during their public sponsorship testimony, they ignore questions. And then we have Rep. Williams, who isn't here right now, that is willing to grill advocates, but not bring the same intensity against Senator Huffman over there. In my personal experience, many of you don't even know the difference between THCA, Delta 9, and Delta 8. That is core to the market that is legal. That is core to the hemp bills that we are going after right now. That is core to what the federal government did that started this whole hiccup in the first place. I recognize that we are hearing testimony in House Bill 160 and will focus my comments as such, but to attempt to move all of these bills concurrently and hastily through the legislature is overwhelming to the average citizen who did not spend their time drafting, discussing, and defending legislation. I had some other comments about how I felt leaving this building last time because the Senate ignored me, but I'm very happy to be here today with you all who have been asking questions, who have been answering some of my phone calls, and I very much appreciate the people's house, as Rep. Callender likes to call it. Rather than proposing legislation, quote, as close to issue 2 while still passing, as was stated in his sponsorship testimony, Representative Stewart, who is missing today, his bill aims to ignore or countermand many of the strictures central to the language of the citizen-initiated statute by an overwhelming majority of voters in this state, recriminalizing public consumption, ignoring the social equity program, removing level 3 licenses, and releasing funds directly to the GRF rather than empowering the Department of Taxation to disperse the funds they are currently withholding from cities and localities are just a few of the most notable failures in this legislation. I am currently working with representatives from Ohio's Capitol building on drafting a framework for legislation regarding cannabis in the great state of Ohio. I work with the OCC that's been mentioned a few times today. I am working with the ACLU and Normal National. I'm speaking with citizens, patients, homegrowers, hobbyists, research scientists, legal organizations, unions, activists, and more. I want to say a couple other things, but this one's important to me. I ask that you don't make criminals out of law-abiding citizens. I ask that you vote down this stress test of our democratic system. I do have amendments that I would recommend today if asked, but I do not want to waste my time. Finally, democracy is being tested all over this country. I wake up scared, overwhelmed, and helpless most days, and definitely angry. Today, I have an opportunity to stand up for people that weren't able to make their way out here today, so I am speaking up and answering your questions. I will be attending the Cannabis Town Hall this evening put on by an associate that was already speaking to you today. You can contact me at contact@ebthc@gmail.com if you would like to support the legislation. But in my opinion, House Bill 160 is a failure and we need to start the conversation over. The Constitution of this state says that the job of the House and the Senate is to facilitate the bills that are passed and initiated statutes, not to change what is in there.
Sir, please direct your comments to
Through
the chair.
the chair, I'm sorry. I find that I couldn't speak to him the last couple of times that he was here, so I found myself pretty upset about that. My testimony is done. I'm willing to accept questions.
Any questions for the witness, Representative Mohammed?
Thank you very much. Not a question, but really a comment. Thank you very much for being here, Mr. Whitted. I appreciate that. Again, we've been saying it over and over again. Informed citizens coming forward and speaking and educating the public on what's happening is essential. So I appreciate that, and thank you very much. I'll see you at Town Hall.
Thank you. I am including a education program funded by the state in my proposition because the state has been failing its people in educating them. When we don't know the difference between THCA and synthetic cannabinoids and try to legislate on that, that's alarming to the citizens. So thank you, and I will see you tonight.
Representative Sandberg with a question.
Yes, thank you, Chairman. Thank you for your testimony today. You've mentioned all these different types of cannabinoids, THC, Delta 8, Delta 9, and can you explain the difference? And also, do you agree that there need to be some limits on what is sold and how it's sold and regulated?
Yes, sir. I was hoping Callender would be here. Sorry, through the chair to the rep. I was hoping that the other representative would be here that brought in the joint today. If you ask me, that is most likely a THC, Delta 9, or Delta 10 synthetic joint. Now, there's a simple language that could be included in any bill, whereas cannabis is considered hemp that naturally produces or has naturally occurring Delta 9, and where synthetic tetrahydrocannabinol is in an unstable isomer is not illegal and not for sale. Now, THCA is what grows in the plant. It's in the joints that I have that I carry around with me and share with friends. It's in the joint that I smoked for my friend this morning. When it hits 450 degrees, the acid in that molecule breaks down, and then on the 9th carbon atom, there is a double bond. That's what makes it psychoactive. So when we talk about Delta 8 and Delta 9, those occur at very minimal levels in naturally occurring hemp and cannabis. Now, what we have in this market is synthetic Delta 8, synthetic Delta 10, that we don't understand what we're legislating on, and you're confusing the public rather than educating them and then asking them to sell this in a dispensary where we're already having to spend time in dispensaries educating. I have built, for my level 1 cultivator, I've built an education program about remediation and about these minor cannabinoids that the state has continued to not educate about. Thank you.
Um, yeah, no follow-up. Thank you. Thank you, Chair. Thank you.
Any other questions for the witness? Seeing none, thank you for your testimony.
Thank you.
Our next witness is Cameron Motley. Not seeing Cameron. We just lost. Our next witness is Ronnie Smith. Welcome. Please proceed when you're ready.
Chairman Thomas, members of the city, thank you for allowing me to speak. My name is Ronnie Smith, and I'm a disabled veteran from Athens, Ohio. I own a company called Ohio Boys, and I'm also in the process of starting a nonprofit called Ohio's Homegrown Veterans. My mission is to help as many veterans as I can by giving them an alternative route instead of the aftercare offered by the VA. After high school, I had no direction in life except for alcohol and whatever else I could get my hands on. I found myself in constant trouble with the law, so I signed up for the Army. I was assigned to the 101st Airborne Division, Air Assault, out of Fort Campbell, Kentucky. I spent a deployment in Baghdad, Iraq from 05 to 06. I was also promoted to sergeant. Shortly after returning from the war, I was honorably discharged from the military. So they sent me on my way with a handful of pills and said, good luck. Spent the next 10 years battling my addictions from the prescriptions. Had a hard time developing a relationship with anyone except for the pills. The pills became my new best friend. I still had the war in my head, but the pills made everything seem okay. Started growing cannabis during this time and was finding some peace. Unfortunately, the peace I was finding through growing this plant was constantly being interrupted by the law telling me it was wrong. I've been busted 4 times indoors in Athens County, where I now grow freely. I'm a veteran advocate for cannabis in the community, and I'm part of a panel that teaches a homegrown workshop at the Cannabis Museum. Come check it out if you want. Teach you guys how to grow. I give free seeds and free weed to veterans. These veterans are happy to get the medicine I give to them. Most are stuck in the same shoes I found myself in. Pills, pills, and more pills. No quality of life, stuck at home with depression, anxiety, and a bunch of unhealed traumas. Anger, failed relationships, and a hard time trying to cope, just to name a few. The cannabis laws in place allow me to give to these veterans. If the laws get changed, it will prevent me from doing so. I will not stop giving free weed to veterans on the regular. And I will not do that. They like it, and I'm helping people. So I do this a few times per year, and I've been doing it more and more with the amount of medicine that's being donated to me for this cause. Ohio's trying to prevent me from giving free medicine to veterans who need it and can't afford it, and that's just wrong. Please stop trying to change something that's working and focus your time on helping us grow more. We need more plants so we can continue growing and healing. This plant is here for a reason and is the safest medicine on earth. Thank you for your time. I'll be happy to answer any questions you may have.
Mr. Smith, thank you for your testimony and thank you for your service.
You're welcome.
Ranking Member Isaacson with question.
Thank you, Chair. Sir, thank you for your service and thank you for your advocacy and your passion. It really comes across, and we need more veterans taking care of one another.
Thank you, man.
So thank you.
You're welcome.
My question for you is, the country sent you to go fight for freedom and to spread freedom. Would you say that you are here advocating to make and continue the state being more free or less free?
Can you repeat that, please?
Are you advocating for the state of Ohio to have more freedom or less freedom?
More freedom. Absolutely. Yeah, because I fought for this plant. I fought for this country, right? Came back, stuck with the war, fed the pills, right? Nothing worked, man. I went to prison. I did 5 years in prison. So I did 5 years in prison, read some books in prison, read the Bible, read the Teachings of Buddha, read the Tao Te Ching, trying to understand what this world's about and what I'm here to do, right? I found out, man, it's for me to get out, build my genetics company, which I successfully done, and to give as much weed as I can to people who need it and can't afford it. And number one is my veterans. I'll get a little story. Last night I'm in Menards in Athens, right? I'm in there taking a piss. This guy walks in, he's like on crutches, right? And I can hear him grunting. Got a fire department shirt on out of Albany, Ohio. I live in Athens. And I was sitting there washing my hands. I couldn't help, man. I heard him grunting. He's leaning over I'm like, sir, you look like you're in a lot of pain. I'd like to help you. He's like, I'm in a lot of pain, right? Walk outside, get my number. Have my girl walk out the car, get some medicine, my medicine bag, come in, give him some hash rosin gummies, right? That were handcrafted by a kid that vended an event with me last weekend. I gave him them hash rosin gummies. went to the back of the store. It's where him and his wife was at. I met him, met his wife, and they thanked me so much. He's got the pills, he got the narcotics, but he don't want the narcotics. He don't like the way they make him feel, man. He don't like that. So he's in there in pain and grunting. So I'm waiting today. He's going to call me today and let me know how the medication worked for him. So if it works for him, I got RSO that gets donated to me in large jars, and I put it in these syringes and I give it to people who need it, man. And it really helps a lot of people. It does. And I set up in Athens. Here's the thing, in Athens, I'm on paper right now. I got 4 years stored in my head from prison, right? I set up in Athens a booth, my Sahaya Boy stuff, and get free weed and seize the veterans at her grow shop in Athens, man. And the community's fine with it. The sheriff, the cops, they're totally fine with that. And I'm on paper in that county. I don't know.
Further question?
Yes, thank you, Chairman. Thank you for coming in, sharing your story. As Rep. Isaacson mentioned, thank you for your service, everything. It's very inspiring.
Thank you.
This is going to sound weird, but I'll just you appear to be in pretty good physical condition.
Sure.
So do you work out, exercise?
Sure I do. Yep, I'm actually running. I'm actually in better shape now. I was in the Army. I ran like a 12:08 2-mile. Now I can run like a 13-minute 2-mile. So I'm like about the same. I was in the Army. They was giving me pills while I was in the Army. I was snorting pills in the bathroom during formations, literally. In Iraq, I was in the Porta-John smelling shit, snorting pills. As an addict, man. Wasn't in no kind of shape, wasn't in any kind of mind state to take care of any kind of mission, right? They was giving me the pills, fighting the war for these guys, giving me just a fucking, I got out, dude, I was lost, really. I'm still kind of lost. I healed myself from the war. I just don't understand what that war is about to this day. I really don't. I was fighting a bunch of people that weren't my enemies. I clearly saw it in their eyes that they did not want to fight against me. I feel really bad about some of the things I did over there, man. But I'm healed from that stuff. And I'm trying to get the rest of this shit figured out. Sorry.
Thank you. Understood. I guess my follow-up and my whole point in even asking that is that there's a stigma out there that cannabis users are lazy and they sit around. And,
yep. I'm in the gym every day, man.
So
I run once a week just to make sure I can maintain that, and I'm always there. I turkey hunt. I guide kids. I guide veterans on turkey hunts with my time. I do that out of my heart, man. I just love giving and helping people. And that gym, I've met so many people in there, business owners out of Athens, Butcher Bites, the guy that owns the gym. The guy that owned the gym, I taught him how to grow weed, man. Like the Butcher Bites guy, I'm able to trade weed plants for my meals, man, in Athens. So, and yeah, I'm in there every day, and these guys respect me. When I first walk in there, I smell like weed. I got weed hoodies on. Yeah, man. And I go in there and go hard as all of them, and they respect that. And I hope you guys respect that too.
Thank you.
Yep.
Representative Timms with the question.
Thank you, Chair, and to the witness. Thank you so much for being here and for sharing your story. We really felt your passion and are really grateful for your service.
Thank you.
To keep us all safe. I guess one question I have is, and I know there's probably a number of things in the bill that will harm you, but what is the most devastating portion of the bill that would affect your business and what you are currently doing in Athens?
My thing is the gifting. So I found that's my meaning right now, man. I did a giveaway today. I jumped on Facebook on my way here and said I'm going to continue fighting for this plant. They're trying to make it where I can't give, so I'm going to go ahead and give a ½ ounce of Bubba Kush grown in living organic soil that was donated to me by somebody. They're all in there hitting on it. They want that free Bubba Kush. Like, I like giving. That's giving me, makes me feel, it gives me a meaning in life. So what it does, I like to help people, and then people look up to me and rely on me for help, and that's where I'm at right now. So that's why I'm not going to let them people down. I done started giving something and developing something for these people, a hub to come and get medicine freely, right, in Athens for veterans, for people that got cancer, for really anybody that needs it. I'm getting so much given to me and gifted to me that I have a big bag of weed like this to give. Like, I don't have enough people to give it to. So, and the people I'm giving it to are really grateful. They're on there once a week thanking me. I mean, they want more. Sure they do. And I want to make it where I can continue to give more and more, because there's plenty of donations. There's plenty of herb. All the weed they grow that gets tore up every year, or that stuff can be given to me to give to these veterans. So there's plenty of weed that's getting destroyed because of whatever, right? And I want to give weed away. That's what I want to do for the rest of my life. So that's what would bother me about it.
Sure. Yes.
And in your opinion and based on your experience, are there any limitations you would be open to or that you would consider as it comes to the transportation and movement of marijuana?
Can you say that again?
Are there any limitations or constraints?
Absolutely.
That you would support?
Sure. Yep. I mean, yeah, because I need to haul, like the whole weed. Absolutely. If you give it away, is that what you mean? I don't know what your question is, honestly.
Is there a limit that you would agree with in terms of giving it to someone? Would you give somebody?
I give a quarter ounce of weed to people and a gram of Rick Simpson oil and 3 seeds. I don't know.
So, okay, the chair,
Follow-up.
follow-up, thank you. I guess I'll ask a clarifying question. This committee, we are trying to come up with legislation and policy that would essentially, despite I disagree with a lot of us in here,
Sure.
but some of it is, I understand the intention of it, right?
Okay.
And the intention is to protect the public and keep people safe, to protect them from overdosing or overindulging in marijuana. And my question to you as someone who gives it away, is there an amount that you yourself would limit? If you were a lawmaker, how much would you limit or restrain so that people couldn't overindulge or overuse marijuana? Is
I don't
there
think
an
you can
amount?
overuse marijuana, though. I honestly don't. Last night I ate 2 grams of Rick Simpson oil, which is around 2,000 milligrams. And I function totally fine. I mean, I understand some people get high, but they're not getting high and acting crazy, right? They're getting high and going laying down. They're not getting in their car and driving, and that ain't what they're doing. If somebody gets too high, is going to lay down somewhere. They get paranoid, right? And they don't want to be in public. They don't want to be out driving a car. No, they want to get somewhere. They're not going to be driving a car because they're not going to get in the car and drive if they got too much marijuana. It's a stigma thing, right? It's exactly what it is. That's why I mentioned weed in here. We're weed heads. You guys, we're doing weed heads, but it's medicine now. So I like transition that. It's a stigma thing, and it always will be. But people don't like it or going to continue to not like it, right? That's fine, but respect us.
Great. Any other questions? Representative Sindberg.
Just as follow-up, and like when you have this fire officer that came to you, or that you saw last night, or a couple nights ago, the fire.
Yeah, last night. Yep.
Do you give a warning of, hey, here's how what I'm going to give you, here's how much you should?
Yeah.
consume?
I give a recommended dose. Yeah, these were 20 milligrams a piece, hash rosin and gummies. A normal dose for people is like 10. So I told him to take a quarter of that, which would be like 5 milligrams. I said, call me tomorrow. Let me know what that did for you. Then we'll go from there. Tomorrow you can take, half of that. You can take a whole half. Then maybe if that's okay with you, if that ain't filling nothing, take a whole one. So I do recommend. I don't worry about somebody overdosing. That ain't never been a thing. Nobody's ever overdosed on marijuana ever. So I recommend a dose. If he went home and took too much, he sleeps all night and sleeps 2 extra hours in the morning. You might like that. It's still medicine. We only sleep.
Thank you.
Yep.
Seeing no further questions, thank you for your testimony. There are 3 people who are on the list. I just thought I'd check again. Is Kat Packer here? Ashley Mosby, Charles Ellis, Cameron Motley. It's the 4, sorry. If you've not seen them, please note that there is written testimony as well on your iPads, and that will, this concludes the 3rd hearing for House Bill 160. I'd now like to call up House Bill 198 for its 3rd hearing. And Corey Harris is the first person to provide testimony. Is Corey here? Welcome.
Welcome. Good morning, or we might be pretty dangerously close to afternoon at this point in time. I appreciate the opportunity to be here. Wish I'd had an opportunity to be before perhaps some of the last conversation, especially in regards to hemp and how it's treated federally. So Mr. Chairman, Vice Chairman, Ranking Member, members of the committee, really appreciate the opportunity to be here today to discuss concerns with House Bill 198 and offer insights as the General Assembly considers how it will be regulating intoxicating products derived from hemp. My name is Corey Harris. I'm a principal at the Vogel Group, a top Washington-based law firm, representing more than 200 clients from across all sectors, all business types, and across the globe. In my role at Vogel Group, I actually lead our firm's agriculture practice group, where I leverage a lifetime of experience in that sector to help clients navigate complex issues and nuances of ag policy. I represent the American Trade Association for Cannabis and Hemp, or ATTACH as it's known, in its efforts to address and close the loophole created in the 2018 Farm Bill that inadvertently opened the door and floodgate on a massive gray market for intoxicating cannabis equivalent products marketed under the guise of hemp. In this time, ATTACH has become the leading voice of this effort on Capitol Hill and a trusted resource for lawmakers as they navigate the challenging dynamics, science, and nomenclature of this issue. ATTACH is a 501c6 trade association registered in Washington, D.C., represents state-regulated cannabis and hemp businesses across the country. ATTACH was founded 11 years ago to support businesses engaged in state-licensed medical and adult use production and the sale of marijuana and hemp products, and more importantly, to advocate for consumer safety around these products. ATTACH serves as a founding member and retains its seat on Standards Association, ASTM International's D37 committee, which is focused on cannabis and hemp standards. ATTACH is situated at the forefront of cannabis policy discussions because of its advocacy to better regulate and more stringent standards on those businesses, and because of its role as a bridge between policymakers, the regulated cannabis industry, and its regulators. In my remarks this afternoon, I intend to focus on three key areas: how we got here and what your experience in terms of intoxicating hemp, what these products are and what they're not, and how this bill, HB 198, falls short of what seems to be the General Assembly's intent to gain control of the unregulated intoxicating hemp products that have proliferated across the state. So let's talk about how we got here and what the Farm Bill is and what the intent was of this policy and what the reality is. The Farm Bill is a piece of legislation that's reauthorized by Congress roughly every 5 years. This bill contains authorizing instructions for nearly all programs within the jurisdiction of the U.S. Department of Agriculture, from farm programs like crop insurance to nutrition programs like SNAP, and hundreds of more in between that you'll likely have never known that existed. An important aspect here is that while this bill covers hundreds of programs, rules, and instructions for the department, what it doesn't really do is regulate consumer products, as those activities and the enforcement they require are generally outside of the department's scope. So what was the intent of the 2018 Farm Bill and its language around hemp? 2018 reauthorization of the Farm Bill included a new provision aimed at re-legalizing the production and processing of hemp for industrial purposes, such as fiber, rope, oil, feed, and other products not intended for human consumption. The motivation being that if Congress unlocked this previous crop, widely grown prior to its banning in the early 70s under the Controlled Substances Act, it would give farmers who were navigating the challenging economics at the time a new crop and a new opportunity to diversify their operations, especially the farmers that had been negatively impacted by the tobacco buyout program of the early 2000s. Congressional Ag Committee members wanted to allow for the production of non-intoxicating hemp as an industrial crop, but wanted to make no concession in the federal treatment of marijuana. So how did it work? What did they do in the bill? Because hemp and cannabis are merely different varietals of the same exact plant, Cannabis sativa L, and because Congress, especially those who authored this provision, had no appetite to legalize marijuana, lawmakers on the Congressional Ag Committees had to create a new legal definition of hemp and then exclude the varietals that met that definition from the Controlled Substances Act in order to legalize its production. They did so with new legal definition that says basically hemp is defined as the plant Cannabis sativa L and all of its derivatives that contain less than 0.3% delta-9 THC on a dry weight basis. So what went wrong there? The legal framework created in the Farm Bill relied on four key assumptions. The first being that delta-9 THC is the only compound that can get you high. 2, that cannabis is consumed through inhalation. 3, that 0.3% was an appropriate de minimis limit on THC. And 4, that the USDA's regulation of plants in the field would limit the products that could get to consumers and prevent intoxicants from being sold directly or indirectly for human consumption. While these assumptions weren't inherently wrong, they also weren't correct. The Cannabis sativa L plant contains more than 100 different cannabinoids, including dozens of tetrahydrocannabinoids, all of which are intoxicating. While marijuana is typically consumed via smoke inhalation, it is also often consumed by ingestion, insertion, topical application, or vapor inhalation, with nearly identical intoxicating effect. If applied only to smoke inhalation, this is the third point, 0.3% of dry weight is perfectly acceptable cap on THC. An individual couldn't smoke that fast enough. You couldn't smoke a joint fast enough to get high. However, this metric ignores the fact that THCA, the most common cannabinoid found in marijuana, is a precursor to THC and can be easily converted to THC by heating, smoking, vaping, or cooking. This metric also fails to acknowledge that other modes of action described above. When applied to ingestible products, 0.3% becomes an escalating weight function. That means that the heavier the item is that's being sold, the greater quantity of delta-9 THC it can contain and still remain below 0.3%. This function allows for a 1.86 ounce candy bar, I think this is the data I was using here, to contain as much as 165 milligrams of THC, delta-9 THC. Or for other reference, if a 16-ounce beverage could contain as much as 1,440 milligrams of delta-9 THC. And the fourth area where they assumed wrongly is that because Farm Bill writers assumed that they had removed any interest in human consumption of the hemp plant by prohibiting delta-9 THC, they also assumed that USDA's inspection of plants in the field within 30 days prior to harvest would be sufficient to regulate any products granted new authority or direction to FDA and the regulatory authority to enforce those products. So basically they assumed that people wouldn't want to consume hemp. So they said, okay, as long as we know that the plant in the field isn't that hot, then it doesn't matter. We can't get the hot products because they didn't think that they were allowing for the opportunity for final form products to get to market. So let's talk about what these products are and what they are not. Hemp-derived intoxicants are functionally equivalent to marijuana. That's really important here. Simply put, hemp intoxicants are marijuana. In their purest form, these products come from the same exact plant as marijuana. They are used for the same purpose as marijuana, and they contain chemically identical delta-9 THC or synthetically altered versions of THC that are most often more intoxicating than delta-9. In terms of product category, these products are indistinguishable from marijuana. Hemp-derived intoxicants other than delta-9 THC are designed to be synthetic substitutes for marijuana, something the DEA and the state of Ohio have prohibited in the past. These products are chemically altered or converted cannabinoids such as delta-8 THC, delta-10, HHC, THCP, THCO, and a litany of other alphabet soup. These modified compounds produce the same impairing effects as marijuana-derived THC. They are often sold as vapes, edibles, and flour, and marketing as legal under the 2018 Farm Bill. You've heard that dozens of times this morning already. Despite posing much greater public health risks than regulated cannabis products, these substances largely bypass state regulatory systems, creating a parallel marketplace with little oversight, inconsistent testing, and minimal consumer protections. Additionally, and as mentioned above, many of these new cannabinoids are many times more potent than the THC unaltered or regulated marijuana. This new class of designer drugs and the processes used to create them pose significant new public health issues, especially in a marketplace that is entirely unregulated. Hemp intoxicants are not about farmers. That's what these products are not. These products are not agriculture. They are no more agriculture than whiskey or vodka or pumpkin pie is agriculture. All may be derived from an agricultural commodity, but in their final form, they've become far more than that raw input. The exact same is true of intoxicating hemp products. These products are not coming from US-grown, USDA-regulated hemp farms. For context, hemp farming in the United States has sharply declined since the passage of the 2018 Farm Bill, with acreage dropping from 160,000 acres in 2019 to just 22,000 acres in 2023. In Ohio, farmers planted only 170 acres of hemp in 2023, harvesting mere 120 acres of that. But to put that in perspective, you wouldn't call a 120-acre farm of corn and soybeans a farm. It would be a hobby at best. Compare that to the state's 475 million acres of soybeans, 3.6 million acres of corn, and 650,000 acres of wheat harvested the same year. In fact, the U.S. now operates a significant trade deficit for hemp, importing many times more than we produce. The reality is that much of the hemp used for synthetic THC production comes from countries like China, India, and Eastern Europe, where U.S. regulators have little to no oversight. This raises serious concerns about product quality and safety, especially when compared to the rigorous standards applied to state licensed cannabis businesses. Consumers should be careful about consuming products made from Chinese hemp without a thorough battery of lab tests. However, due to changing views about the safety of natural marijuana and no enforcement mechanism to keep producers honest, these issues often fly under the radar with consumers who assume that they are getting natural despite it being entirely synthetic. What these products are not also is while they are functionally equivalent to cannabis, they're not equivalent to marijuana in terms of safety. It's important to acknowledge that intoxicating hemp-derived products and state-regulated cannabis products are often functionally identical in their chemical composition and pharmacological effect. However, these products, often synthesized from CBD and to these other substances, are chemically similar or structurally analogous to delta-9, the principal intoxicant. The result is the same, a product that produces intoxication impairment. While these synthesized cannabinoids have similar or more potent intoxicating effects relative to delta-9, they don't necessarily have the same safety profile. For thousands of years, man has consumed the cannabis plant, the delta-9 in its purest form, and a significant amount of scientific research has been conducted on this drug. Conversely, the vast majority of synthetic cannabinoids are novel compounds developed in a lab within the past 10 years with the express intent of being as easily received by the body as possible. Put this more plainly, these compounds are designer drugs created for maximum potency, for which we have essentially zero clinical data available to understand the pharmacological and long-term health effects. Am I up?
Yes.
Give me just a moment. That's very good. Another key difference lies not just in the product itself, but also in how it's regulated. Ohio's marijuana program imposes strict licensing, advertising rules, product tracking, child access prevention, labeling requirements, testing for potency and contaminants, consumer protection rules, agricultural and food production standards, and tax collection, all of which are absent from HB 198. The bill creates a separate pathway for selling the same product with none of the same guardrails, protection, or accountability. It is the equivalent of authorizing an unlimited number of new, unregulated pharmaceutical compounds for sale in convenience stores simply because manufacturers choose to label them differently. This bifurcation approach threatens to destabilize Ohio's legal cannabis market and invites public confusion about what is legal, what is safe, and who is responsible. There's a little bit more in my written remarks that I invite you to read, but in the interest of time, I'm happy to address any questions.
Mr. Harris, thanks for your testimony. Thanks for the history. And rest assured, we all have it and it becomes part of the record. Any questions from Mr. Harris?
This is easy. I was looking for a grilling. You said you had questions for everybody. I actually would like to address something said by a couple of folks on the previous bill about the inability for someone to overdose on marijuana. I think there's some lack of data, I guess, that would suggest that that is true about smokable marijuana over time. But what we have seen is that it is entirely possible to overdose on these products. People have died. Children have died a handful of times because of these products. We've seen dozens, if not hundreds or thousands of people go to the hospital because of these products. And while, yes, it may be true that adults, if they get too high on marijuana, are just going to get lethargic and go to sleep, that's still a pretty adverse impact of something that you're not in control of. And that's not the same impact that's going to happen to a child. And while we may not openly give these products to a child, or many of us may be responsible enough to lock them up, the product you had earlier today, I think it was a drink mix, but it literally had okay, well, we often see those as candies or drink mixes or whatever that look very similar in packaging to that. But just imagine for a moment you have a small child and your babysitter comes over and that falls out of their backpack. Would your child know that that product isn't intoxicating, couldn't send them to the hospital or even kill them? And the answer is almost certainly that it's a recipe for disaster. That was a great question, sir.
Any questions? Seeing none, thank you for your testimony.
Thank you, guys.
Our next witness is David Poland.
Thank you, and thank you all for taking the time today to listen. Chairman, Vice Chair, Ranking Member, and members of the committee, thank you for the opportunity to testify on behalf of the Ohio Cannabis Coalition. We represent licensed cultivators, processors, dispensaries, testing laboratories, and ancillary businesses that operate in Ohio's cannabis industry. We stand in opposition to House Bill 198, a piece of legislation that, under the guise of regulation, will legitimize and expand the dangerous and unregulated market of intoxicating hemp products in Ohio. This bill is not about regulating wellness products or supporting Ohio farmers and small businesses. It is about paving the way for a market that traffics in chemically modified synthetic drugs, mimicking the effects of marijuana without any of the safety protocols. The proliferation of hemp-derived synthetic intoxicants like HHC, THCO, and THCP represents one of the most pressing public health threats in our state. These products are often synthesized in labs and sprayed onto plant material before being openly sold in gas stations, convenience stores, and smoke shops with no age restrictions, no testing, and no labeling standards. These products are then marketed directly to children with bright colors and cartoon characters, and frequently are packaged to mimic popular candies and snacks. These aren't rare incidents. Each committee member could take a walk in our community and find these products being sold. House Bill 198 will not fix these problems. In fact, it will compound them. This bill allows chemically produced synthetic cannabinoids, does not impose limits on potency, lacks comprehensive testing standards, and provides minimal funding for enforcement. Of grave concern is the portion of this legislation that includes a safe harbor provision for production of these products, making Ohio a national hub for the manufacture of dangerous, mislabeled hemp-derived drugs for export to other states. Unlike Ohio's regulated cannabis industry, which is tested, taxed, and strictly age-gated, this bill creates a second parallel market that is cheaper, more potent, and completely unaccountable. It lets bad actors sidestep the entire regulatory framework that we spent years building to protect public health. This is not regulation, it is deregulation poorly disguised, placing the profit of a few over Ohioans' health. Ohio must not become a sanctuary for the production and sale of synthetic intoxicating hemp products. We urge the legislature to reject House Bill 198 and instead pursue comprehensive legislation that will hold bad actors accountable and align all intoxicating products, whether hemp-derived or not, under a single regulated public health-focused framework. We have just seen the unanimous passage of Senate Bill 86 in the Senate. This is the type of legislation we should be pursuing. Thank you, and happy to take any questions.
Thank you for your testimony. Any questions? Representative Sandberg.
Chairman, and thank you for your testimony today. On the beverages part of the hemp beverages, where does the coalition stand on that?
Chairman, Representative, we believe that the beverages, because they're low dose, they've been set at 5 milligrams max per container. We believe they're acceptable and also find them to be acceptable because they too would be regulated under an existing framework that we have in the Division of Liquor Control. So we already have a framework set up, which is completely different than what we have going on in intoxicating hemp, pushing it through ag. So yes, to answer your question, yes, we are okay with beverages because of the existing regulatory framework.
Follow?
Yes, please, Chairman. And as far as point of sale for beverages, do you have a?
We are okay with how it was in Senate Bill 86, which was done to carry out. I think it limited exactly to carry out stores, grocery stores, but limited the on-premise consumption at bars and restaurants. So we are okay with it where it stands today.
And not money, no bar and restaurant sales.
It's not really our issue, so yes, correct.
Okay. Follow. Yeah, thank you. Thank you.
All right. Do you know for the questions?
Thank you. Thank you again for your time.
Next testimony comes from Wesley Bryant. Welcome back.
Thank you. I'm back again. I had Joey Elwood moving his to written only. Get to step out. Chairman Thomas, Vice Chair Matthews, Ranking Member Isaacson, and members of the committee, thank you for the opportunity to provide testimony today as an interested party on the House Bill 198. My name is Wesley Bryant again. I'm the founder and CEO of 420 Craft Beverages, a Cleveland-based manufacturing company specializing in infused drinkable cannabinoid products distributed through Ohio. I commend the bill sponsors for the proactive approach in addressing the regulation of hemp-derived consumables. While not perfect, 198 recognizes the need for a balanced regulatory framework that ensures consumer safety while supporting Ohio's burgeoning hemp industry. The strengths of 198 that I see is it establishes a hemp licensing pathway independent of the marijuana program. It allows for hemp consumables to remain accessible through retail, online, and wholesale channels, recognizes the need for age restriction and labeling protections to prevent youth targeting, and creates foundational safety standards and product registration systems that can evolve with the market. These are critical safeguards that maintain consumer confidence without crippling small businesses. Still, HB 198 must be further refined to ensure it aligns with the federal law, distinguishes between product categories, and guarantees Ohio hemp stakeholders fair treatment in future regulatory transitions. Here are the key areas of improvement and proposed language support that that I could see. It's all written down there for you. I'm just going to jump through them. You guys have been here long enough today, so I want to respect your time. Distinguishing cultivation versus product testing. Real key thing is testing hemp cultivation in field versus testing it at a retail establishment. Codifying work in progress. This is something that was lacking in the 2019 hemp bill here in Ohio that the USDA recognizes. I don't understand why Ohio doesn't recognize that. Directed retail sales and vertical integration. Fair and accessible licensing. Hemp to cannabis license reciprocity. You guys have a hemp program here that's been established since 2019. You guys are looking at somewhere to possibly put some of that social equity money. You guys have a full hemp program here that's been operating under the laws set forth by Ohio. I think that probably could be a little piece to play with. Dispensary access or fully compliant hemp products. If these products meet the standard and we can establish a framework to get those into the DCC, into dispensaries, if these guys want to carry beverages, by all means, let them carry the beverages. I'd be more than happy to make quite a few. As a matter of fact, I already work with a few of the guys making them on their hemp side. In conclusion, HB 198 is an important and commendable step forward toward regulating hemp-derived consumables in Ohio. It still needs some adjustment to ensure compliance with federal law, fairness for existing business, and long-term scalability. The additions we propose are not radical departures. They're clarifying enhancements grounded in federal guidance, industry experience, and economic pragmatism. We believe these updates will strengthen HB 198 while maintaining its core integrity. Thank you for your time and commitment to getting this right, and I'm open to questions, please.
Great. Any questions for the witness? Seeing none? Thank you.
All right, guys. Thank you so much.
And Mr. Blank, you said, well, Joey Elwood's up next, and you said he's not available. Got it. Thank you. Seeing no further testimony on House Bill 198, that will conclude the third hearing for House Bill 198. Seeing no further business before the committee now stands adjourned.